onto the roof here.
Okay. Well, we'll work through scheduling after we have a new arraignment, and that'll really be what moves things forward. I'll take this case off the trial calendar. It doesn't make sense to move forward on what would be an incomplete indictment, and it's still peculiar the way this particular indictment is structured with two defendants with no overlapping charges. So what we'll do is continue this, and then I'll see everyone next for the arraignment. Mr. Mann, your client will need to come to court for the arraignment. Whether you or Ms. Teal are appearing virtually is up to you to negotiate with your client. But you're hearing me say it now. Mr. Salmeron needs to come to court for the arraignment, okay?
Yes, Judge, can you just reiterate the time and date right now that you'd be having arraignments?
No, there is not a date. There's not a new indictment. So
okay.
It's not until Mr. Shapiro forecast that the indictment will be tomorrow. It's a related case, so it'll get assigned to me pretty promptly. But my litigation manager will set that arraignment date, and notice will go out to you and to Mr. Salmeron.
Understood. And for the record, Judge, I will be present with my client. I'll come to court.
Okay, sounds good. We will see you then.
Okay, thank you, Judge. May I be excused?
Yes, sir.
All right, thank you. Have a good day, Judge.
All right. Position 14, Hezekiah Swanson. There's Mr. Swanson. Ms. Wood, you had mentioned to me that Mr. Swanson was contemplating hiring his own lawyer. Has he given you an update?
I think he's sticking with me, Judge.
Smart choice.
I do want to speak with him again after the call of the calendar.
Okay, new offer or just new dynamic?
I presented a counteroffer yesterday to Mr. Jordan, and I will speak to Mr. Jordan about whether that was approved or not.
Okay. Mr. Swanson, you're sitting near people with the same situation. I need you to rest easy while I go through the rest of the calendar, and then Ms. Wood's going to talk to you. She'll let me know whether this is a case that ought to go forward to trial next week, or maybe it'll work out. Please don't leave till I give you the green light, because I need to make sure I get that update from Ms. Wood, okay? Thank you. All right, Mr. Benson pled in his two cases. That gets us to DeQuarius Hopkins.
Hopkins is here. This is the one that we talked about that's with Ms. Hall. So I've spoken with Mr. Hopkins. We just need a plea date. I believe once the paperwork is complete, we have Ms. Hall available. This will be a plea.
Okay, got it. Mr. Hopkins, the prosecutor on this case is in trial right now in another courtroom. She had some work to do to change the charges, and she can't do that while she's in trial. So Ms. Feely, should Ms. Nelson just circle back with you and Ms. Hall to get a date? In other words, assuming there's an accusation in place, just getting you and Mr. Hopkins here is all we need to do. Okay, and I'll let you work with Mr. Hopkins as to whether that's a virtual appearance or in person. If it's a non-custodial outcome, you can manage it however you want. Okay, do you need Mr. Hopkins to stick around?
Not today.
All right, so Mr. Hopkins, when I see you next, either in person or on a screen, it sounds like to me it's because you're resolving your case to very different charges. We just need to get those charges in place. Is that your understanding?
Yes, sir.
Okay, any questions for me?
No, sir.
All right, do you have good contact information from Ms. Feely? All right, you're free to go.
Thank you.
Linda Seals.
Still has mobility issues, but she's there.
Okay, hi, Ms. Seals. You can stay seated. That's fine. Appreciate you being here. This is a case where the alleged victim is traveling, and you shared with me an itinerary. It actually didn't have flight times. It just had Atlanta, destination X, and then coming back here. And so I probed with you a little bit of, well, if we are trying this case, what if we just started later in the week? Are you still ready to go?
We are ready to go. Ms. Seals did share with me that she has a medical appointment on the 18th at 8:30, but certainly if this is going to trial, we'll have to reschedule that, but she did want me to.
Okay, it's a non-emergency, non-life-threatening medical appointment.
Testing before surgery.
Okay, all right. Mr. Jordan, the part that was missing from the itinerary was when your witness would actually be back on that day. I don't remember the day of the week that she was getting back. I know it wasn't Friday, so we had some space in there.
That's correct, Your Honor. She will be gone from the 17th to the 19th. And I can definitely, I believe she sent me more detailed pictures with her itinerary on it. The state did file their motion to continue. We understand that Your Honor would just pick a jury earlier that week and hold to begin until the 20th. Is that correct?
Well, that was my question. So your sense is that your witness gets back late enough on the 19th that it wouldn't make, we could have the jury come in and hear from other witnesses other than the alleged victim and then go home after an hour and then come back. So my thought would be we would do evidence on the 20th. And your sense is that this is a trial. If it's a jury trial, you always do a bench trial, but either way, it's a trial where evidence would not take up more than a day.
Correct, Your Honor. It would be a maximum of 3 witnesses, so it would be a very quick trial.
Okay. Ms. Feely, do you agree that if we picked a jury on Sunday, Monday, Tuesday, or Wednesday, and we'll work with your schedules to see which of those days, we can get jurors on any one of those days. If we started evidence, meaning openings on Thursday, the 20th, the jury would still get it before 5 o'clock on Friday?
I would assume so, yes.
Okay, all right. Okay, do you need Ms. Seals to stick around?
Yeah, I'll reach out to her.
Okay, so Ms. Seals, hopefully you followed that. Your case may get reached next week. Given the day you've got the medical appointment, we'd probably pick a jury on Monday or Wednesday. So you could go to your appointment on Tuesday. And then the evidence, i.e. witnesses testifying, which could include you if that's what you elect to do, that would be on Thursday, the 20th. So you should keep definitely Thursday, Friday open, and then Ms. Feely can let you know which of the 2 days, Monday or Wednesday, we'd be picking a jury. Any questions about that? That's really up to you and Ms. Feely to discuss. I would need Ms. Feely to state on the record real clearly that you are excusing yourself from jury selection. So you all have that conversation, and worst case scenario, if you don't want to be there for it, is that I would have you show up at the beginning of the day, sort of like this, but it would be at 9 a.m. And I just get you to say on the record, Judge, I appreciate that I have a right to be there for jury selection, but if there's not going to be any testimony, you're just picking a jury, I'd prefer not to be here. And if you tell me that on the record, then I'll let you go. Okay, but you'll talk to Ms. Feely about that. She'll give you her thoughts about the wisdom of being here for jury selection versus the necessity, because there's no testimony. It's just picking jurors. Okay. Any other questions?
I have witnesses too.
Okay.
They do it that, so.
We actually did discuss that on Monday with the judge, so yeah, he's aware of that.
Yeah, we'll work through that. All right. Thank you. You are. All right. Mike Tate. There's Mr. Tate.
This is a plea today, Judge.
All right. Number 19, Tate. Ms. Willingham, you ready on it?
It is a plea, Judge. I was just standing up to say agree.
Okay, good. Mr. Brisky pled. Arian Kelly, and I apologize if I mispronounced your first name. It's close. All right.
And Your Honor, the state will be dismissing that case, Your Honor. We did receive the documentation that we spoke about earlier this week. The state, it wasn't the exact documentation that the state was looking for, but we do sufficiently believe that Ms. Kelly is.
Oh, this is the military situation.
Yes, Your Honor. That
Okay.
Ms. Kelly is either in the process of joining the military or is already in the military. So the state feels comfortable after speaking with the victim to dismiss this case.
And the victim is a family member.
Yes, Your Honor.
Okay. And which is it, Ms. Kelly? Are you a soldier or airman or whatever it is now, or you hope to be soon?
No, I am. I get out the chair.
You do what?
No, I get out of the military next year. I'm still currently.
Oh, you're trying to get out. Okay. How long have you been in?
I'm about to be 25 this year. I've been in since I turned 18.
Okay. In what branch?
Army.
Okay. Well, I appreciate your service. I don't know what happened in this case. Hopefully whatever it was is something that cannot happen again, because it was complicated for your life and probably was complicated for whoever was on the receiving end of it.
And Your Honor, if it's okay with the court, if I can submit a detailed null pros for this case, since it does have, state does have reasoning for this.
I trust you have reasoning for it, but it won't be one where you're making an oral motion. We'll look for what you have done in the past, where it's actually a proposed order that you're submitting that has all the language that will memorialize the basis for the dismissal. I'll sign it. So Ms. Kelly, unless Ms. Wood wants you to stay here, you don't need to stay here. It's technically not dismissed yet, but it's going away. I just need to get that proposed order from Mr. Jordan. It may take him a couple of days to get it to me, because you may be hearing him stand up again and again saying, oh, I'll try to be ready on that. But by close of business Friday, you can get that to me?
Your Honor, I understand that there's plenty of other pleas that need to be taken, so I can definitely type that up and send that to Your Honor while we're sitting here.
Oh, well, just like that. So I'll get it signed today or tomorrow morning. Ms. Wood will know when it's official. And then she can either get you a copy of that order, or you can send her a big thank you note for helping you out on your case. But before the week is out, the charges will be gone. Does that get you out of the military sooner? No effect? Okay, all right. Couldn't figure out why you wouldn't say anything. Like Ms. Kelly's case, you're like, Jordan, say something. Bruce Jaluk.
This is a plea, Judge.
All right. Ms. Willingham? All right, Mr. Jaluk, we'll get you up here for a plea as soon as Ms. Wood can make it happen. James Robinson, we already talked about. You need to stick around for Ms. Wood to share with you a possible resolution. Roderick Hargrove. There he is.
Ready.
Thanks, Ray.
Okay, and that made your list. Okay, so Mr. Hargrove, you have rocketed up, even though you're position 24 on the calendar, you've moved way up on possible trials. So it is highly likely that you will need to be here Monday morning, ready to go to trial on your case. Okay?
All right.
Good. Do you need Mr. Hargrove to stick around?
No, Your Honor.
All right, Mr. Hargrove. So Ms. Wood, I promise we'll be in touch with you this week. Does she have good numbers for you?
Yes, sir.
Good. She'll let you know the deal for Monday, because I'll be letting all the lawyers know the deal for Monday, but you will likely be on that short list. I might have 4 or 5 cases show up on Monday. The lawyers will know which one I plan on calling first, so it won't be a surprise. Ms. Wood will be able to tell you, hey, we're number 3, but I think number 2 is going to go away. But I'm pretty certain I'll be seeing you Monday morning. And if yours is then first up, we'll spend most of the week together, a couple days.
Judge, it should just take a couple of days.
Okay, but we'll spend some time together next week. All right? See you then. Mr. Fagerlin has pled. Bakari Briney. Mr. Fortis.
Good afternoon, Judge. How are you?
I am well. Client is here. Everyone stood up. What's happening with this case?
Expect a resolution today.
Okay. Do you need to talk with Mr. Jordan, or that resolution already exists, or where are we?
It exists, Your Honor, and I did want to make a modification to that after reviewing the last recommendation, Your Honor, and I'll speak to Attorney Fortis about it.
Okay, but it's going to be a plea, or it's some other outcome?
At least I believe that we had a negotiated plea.
Yeah,
I
as long
just
as the
need
one
to
component didn't change.
make a tweak to it. It's nothing to the.
All right. Well, I won't get in the middle of it, but I'm adding it to the list of pleas.
Yes, sir.
And what we'll probably do, we'll see, we have a few more to go, but just for planning purposes, probably have that be the first plea, because then Ms. Wood can talk to the few folks she needs to see if her list of pleas is growing, or if those folks will be coming on Monday. Not promising it, but it's probably what we'll do first.
Judge, if I may spend a minute, since we've been in court, I do have the waiver rights. Do I go over those with him?
Yeah, if you want to go do that right now with Mr. Briney, that'd be great. Thanks.
Just making sure. Good to see you, Judge.
Same. I will see you in a moment.
Thank you.
Mr. McCoy, not here, but we are hoping to get him here. And I know Ms. Nelson is going to work her magic. It won't be, this isn't, well, first of all, it's nothing you said you thought would be a trial, but he wouldn't be here by Monday anyway, I suspect. Ms. Nelson, I don't know if you're linkable. Is this one that you think, any sense on when Mr. McCoy will be here?
He will be here probably early May for our next May 8th calendar.
Our next trial calendar, you said?
Yes.
Okay. Okay, great. We'll just, once he gets here, let's sort it out. All right. And we know where he is in state custody. I think you had even said Washington State, but Ms. Nelson doesn't have to hunt around for him.
Right, Washington State Prison, which is out near Augusta.
Okay. All right, Mr. Palmer pled, Mr. Kearse pled, DeMarcus Dixon.
He's in custody, Judge.
Oh, is he here? Great.
This is potentially a plea today, Judge.
You said likely or?
Potentially,
Okay, you need to chat with him?
yes.
Got it. 31 Dixon. Mr. Shapiro, are you able to stick around? Do you need to come back?
No, I can absolutely see right
Okay. All right. Kelly was a plea. Tavante Williams.
Mr. Williams is there.
Hey, Mr. Williams.
The one that we were held to the fire about the report. I do have the report as of yesterday. So this is just a matter of getting together more mitigation evidence. And I think this will just need a plea date, hopefully later this month.
Okay, then that follows my notes. So Mr. Shapiro will want to digest what you pulled together and you had forecast ideally late April plea date. Anything changed from the state side?
No, Your Honor, we just need a chance to review. Ms. Feely's provided us with the information we requested. We'll also discuss it with the victims in this case, but I anticipate we can resolve this by the end of the month as well.
My calendar shows one count. You said victims plural.
No, I'm sorry, Judge, victim.
Okay, all
I
right.
think I said victim's family.
Oh, got it. Okay, excellent. Mr. Williams, your lawyer's been doing some good work on your behalf in an effort to convince the state to approach this case in a different way, favorable to you. I need to make sure Ms. Feely has a little more time to pull more information together, and then more importantly, probably give Mr. Shapiro some time to think through what it is that Ms. Feely has generated on your behalf. You'll remain on bond. You need to comply with all the conditions of bond, which I assume is a stay away as well. So whoever it is you need to stay away from, keep doing that. And then we'll get you back in here, ideally before the month is out, to resolve the case. Does that make sense? Any questions? Do you need Mr. Williams to stay? Okay, I appreciate you being here on time. You are free to go. We will see you in a few weeks. I don't have a specific date yet to resolve the case, okay? All right. That is the calendar. Is there anyone here who was thinking, wait, I was hoping you'd call my case? No? Okay. So let me recap. Ms. Wood, you're going to talk with Mr. Trapatis, and Ms. Feely, you're going to talk with Mr. Clark. Mr. Spencer is gone, but we'll work through that. Smith and Mitchell, no lawyer. You'll talk with Mr. Robinson, Ms. Wood, Mr. Ross, and Mr. Swanson. And then Mr. Hopkins, we let go. And then we've got some pleas. So I am ready with for Mr. Fortis's client's plea as soon as he fills that paperwork out. If you want to sort of hover near him, or at least just let him know they should come in as soon as they're done, and we'll do that so we can keep pressing on. All right. So Mr. Shapiro, you're still here because you may have a plea. Ms. Willingham has 1 million pleas. Mr. Jordan has 1, and we'll keep pressing on. So Ms. Taylor, once we start with these pleas, I'll ask you to spring into action.
All right, Your Honor.
Thank you.
Um, Julian. Okay. Okay, I'll leave it. Thank you.
Your Honor, I went up to Clayton County earlier today and Bonnie Smith said hello.
Is she happy there?
I'm gonna
Yeah,
wait.
she's having a good time.
Good.
Back there.
What were you doing there?
Researching Mr. Cherry.
Oh. Yes, he's coming up.
Yes, he
You're a busy guy.
Yes, very much so.
This is good.
We got good. So then, you know, just put everything. So.
You're not aging a bit. You know how long it's been, I mean, since COVID and everything, it's been 3 years.
It's all of the,
The reverse.
right, the plastic surgery. Ms. Callum, how are you? All right, you are enrolling in Emory, at Emory, medical school straight in or where'd you go to college? Oh, so you've already done college. God, I couldn't find it. I had your high school and then it says medical school. I thought, gosh, that's a leap to go from one to the other. So you've taken care of, I guess that's why you have that research assistant out of Maryland. I mean, that's the whole Baltimore connection from Johns Hopkins. Okay, fantastic. I'm excited for you. Good luck with all that. I've signed the form and I'm putting your driver's license back in the folder. And I'll give this to Captain. He'll get it to you. Thanks for your patience. Sir. Mr. Briney, you can come on up to the podium. They're just filling out the last little bit. You're going to be at the podium for the plea.
I don't know what you're doing on the file. Just 1 second. $500 fine. Okay. Time is valuable work.
All right, we ready? Yeah. Okay. Whoops. Just in time.
It'll project, so you don't need to.
Okay. Let's get started. This is position 26 on the trial calendar. It is State versus Briney. Am I saying your last name correctly? So great. 22 SC 184365. Mr. Briney, you're represented by Mr. Fortis, who is here in court with you. Mr. Jordan is the prosecutor handling your case. And I understand you've reached a negotiated resolution. I'm going to let Mr. Jordan describe all that. It sounds like there may have been some changes in what you're pleading to, et cetera. We'll get all that on the record. You're going to be under oath for this whole process, which means all the answers you give need to be truthful and complete. And it also means that if you've got any questions of your own, you let your lawyer or me know so we can answer those. I need to be comfortable that at the end of this process, you understood what was going on. And if there's anything you don't understand, you just need to call a timeout so we can work through that with you. Will you do that? Excellent. Mr. Jordan.
Your Honor, just for the record, the state will only be proceeding on counts 3 and 4. The state will be dismissing counts 1, 2, and 5 through 7.
Okay, so speeding and reckless driving is what you're moving forward on.
Correct.
Okay.
Mr. Briney, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name?
Bakari Briney.
Are you at this time taking or under the influence of any
I don't know if he's
alcohol?
been sworn.
He just did.
He did? Okay.
Yeah.
I'm sorry.
That's
I
okay.
didn't see him raise his hand. I'm sorry.
He did. He did a good job.
Okay, my bad.
It's all right.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there a medication that you normally take that you have not been given today?
no,
How old are you and how far have you gone in school?
High school diploma, 26.
Okay. Are you able to read, write, and understand the English language?
Yes,
Do you understand that you have been charged with the offenses of speeding and reckless driving?
yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you would receive a jury trial.
yes,
Have you had enough time to speak with your lawyer, Mr. Scott Fortis, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
yes,
Do you need any more time to discuss the case with your attorney?
no,
Are you satisfied with his services?
yes,
Mr. Fortis, do you waive formal reading of the indictment?
We do.
Do you also waive any and all defects in the indictment, including any with respect to Mr. Briney's name?
We do.
Mr. Briney, do you recall having being arrested on these charges?
yes,
Your Honor, the state is unaware of any outstanding warrants that are related to these charges. Mr. Fortis, do you know of any outstanding warrants that are related to these charges?
I do not.
Mr. Briney, has your attorney advised to you the minimum and maximum sentence for each charge that you are pleading to?
yes,
And Your Honor, just for the record, these are both misdemeanors. So the minimum is 1 day in custody and the maximum is 12 months. Mr. Briney, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence? Your Honor, as previously mentioned, the state is dismissing counts 1 and 2 and counts 5 through 7. As to count 3, the state's recommendation is 12 months probation with a $500 fine. As to count 4, the state's recommendation is also 12 months probation to run consecutive to count 3. Mr. Briney, was that the negotiated recommendation that was communicated to you?
yes,
Do you understand that the court does not have to accept that recommendation?
yes,
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
yes,
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
yes,
Are you currently on probation or parole?
You on probation?
yeah, yeah,
Do you understand that since you are currently on probation, your probation may be revoked based on you entering a guilty plea today?
that again?
Do you understand that since you are on probation, that you entering a plea today may result in a revocation of the probation that you're already on?
Yes.
Where are you on probation?
Well, I check in once a month.
Well, are you on probation here in Fulton County or in Cobb County?
For Fulton County?
Fulton County, for a Fulton County case?
Yes, I check in with my PO A Hayes once a month. I do an online form and whatnot, so yeah.
Okay.
Do you understand that since you are being placed on probation as a part of the state's recommendation, that you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes,
Do you understand that you, that's for felonies only, I will move past that question. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
yes,
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
yes,
Do you understand that by pleading guilty, you are giving up the following rights, which I will now list off? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
no,
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Mr. Barney, how do you plead to the charges of speeding and reckless driving in indictment number 22 SC 184365?
Guilty.
Thank you. Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that since these are both misdemeanor charges that you're pleading to, you have only 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Mr. Fortas, did you explain to Mr. Briney his deadline for filing a direct appeal?
I did.
Okay, Your Honor, for a factual basis for this case, on Saturday, February 12th of 2022, an officer from the Georgia State Police Patrol attempted to conduct a traffic stop on a red Honda CBR for traveling at a high rate of speed on I-20 West near I-75 North. The driver of the Honda disregarded the officer's emergency blue lights and siren, initiating a pursuit. The driver of the Honda began driving recklessly while traveling northbound on I-75/85 from I-20 West. The officer whom initially made contact with Mr. Barney did lose sight of the Honda due to heavy traffic conditions. Mr. Barney was later arrested after air support helped to locate the vehicle, and the pursuit was recorded on the officer's dash cam. Your Honor, that concludes the factual basis for the plea. The reasoning that the state felt comfortable extending a misdemeanor plea here is, I believe as I received this case, Mr. Barney only had one cycle. I was not aware of the other Fulton County case that he may be on probation for, but we do understand he is a young person. This, I believe, may have been his first arrest. It was the only cycle on his GCIC when I received it. So we would just ask that Your Honor accept the negotiated plea.
All right. Have you conferred with the trooper to get his perspective on a misdemeanor for someone who, at least as alleged here, was going 120 on our highways right here downtown, I-20 and I-75?
I did reach out, Your Honor. I did not receive a response back from the trooper.
Okay. And other than it was the back and forth between you and Mr. Fortas, is there a factual reason to dismiss things like expired registration and no insurance? I mean, those don't seem like they would be things that'd be a big fight over. Either there was insurance or there wasn't.
Your Honor, I believe, at least from my reading or from being in state court previously, that those are all offenses that if he did plead to may suspend his license. I know registration definitely is one. So the state felt comfortable dismissing those counts. The main concern of the state was to get Mr. Briney under supervision. So we did feel comfortable dismissing those, but I did not receive any documentation that states that the Honda was actually insured or was registered at the time.
Okay. Ms. Jackson, good afternoon. Thank you for being with us. Can you talk to me about Mr. Briney's criminal history?
Your Honor, according to the GCIC, the defendant does not have any prior arrests or convictions. I was attempting to look in Odyssey to see if I could find that probation that he mentioned. If I could have just a moment.
Sure, you can do that. I'm gonna ask Mr. Fortas to try to help us understand this.
Okay, let me add some clarity to this. When he got his bond, he was released through pretrial. So he's been reporting through pretrial, thinking that's some sort of probation.
Well, it's certainly supervision, but it's not probation.
Correct.
Okay.
So there's no reason to look any further.
Got it. Okay, mystery solved. That's pretty impressive. Pretrial's been elevated to probation now. They're so good with their supervision. Nice work, Ms. Jackson, and colleagues. Okay, Mr. Fortas, what do you want to add to the mix?
Judge, I think this is a fair resolution. Mr. Jordan and I have been speaking about this for many, many weeks. And think that the offer is fair under the circumstances and the things that we discussed and the items that I presented to him regarding Mr. Briney, and I would just ask the court to accept the negotiations.
All right, Mr. Briney, do you work?
Yeah, I work.
What do you do?
I drive trucks.
You're a truck driver, so you don't want your license to go away. That's a little concerning. I hope you don't drive trucks 120 miles an hour. You just mow over everyone.
Yes, sir.
Trucker, yikes. Okay. Whose CVR was it that you were trucking along in February of last year?
At the time, I was on the road.
In other words, whose Honda were you driving that day?
It was my motorcycle.
Yours or your mom's?
Mine's.
His.
Mine's.
Okay, got it. Are you an independent trucker or do you work for Schneider or Crete?
I work for somebody now, Energy Dispatch, local.
Okay. And you drive a big truck or a little truck?
Big truck.
Big 18 wheels?
Yeah.
Okay.
I move gas.
You move gas, even better. Okay, so when you do crash into an overpass at 100, it'll be gasoline that you're hauling. Remind me to not be anywhere near you on the road. That'll be a condition of probation. Stay away from Judge McBurney on the freeways.
Right.
Okay. Anything you want to add about this? Like what was going on? Didn't want to get pulled over because you didn't want to lose your CDL, or I'm just trying to figure out how you thought it would end well. The troopers tend not to give up.
Yes, just bad decision. Should have just pulled over, knew better.
What do you any idea why they were going to pull you over in the first? Was it speeding or it wasn't clear from the facts what got them interested in you in the first place?
Just speeding.
Okay.
Just bad decision.
Okay. All right. I'm not singling you out. People speed all the time. They're not necessarily truckers though. So we'll see. Mr. Briney, sounds like you have no criminal history, so I understand why the state was willing to work with you on this. And given your chosen profession, why they were a little flexible on some of the different counts. I mean, it don't really matter to me one way or the other if it's reckless driving versus suspended registration. You may want to keep a current registration if you're driving trucks. Has that been addressed?
Yes.
Okay. All right. Well, I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea, but you're entering it only because, and primarily because you and your lawyer have talked about it and you think this is the right way forward for you. Is that correct?
Correct.
And a knowing plea just means you've understood all the things we talked about. No questions?
No questions.
That means you understand. Do you have the waiver of rights form?
Do, Your Honor.
Okay. Mr. Briney, I'm holding a form that says plea of guilty that has a bunch of initials next to everything on there, most everything on there. Is this a document that you and Mr. Fortis went over?
Correct.
Is this your signature on the bottom of page 4?
Yes.
Okay. And Mr. Fortis, you've signed on page 5.
I have, Your Honor.
You have. Great. Okay. Mr. Briney, your indictment is right now in electronic format in my office. Do you authorize my staff to sign the indictment indicating your guilty plea to counts 3 and 4?
Yes.
Mr. Fortis, can we sign for you?
Yes, Judge.
And Mr. Jordan?
Yes, Your Honor.
All right. Mr. Briney, on count 3 of the indictment, I'm going to sentence you to 12 months. Those will be probated. On count 4, I'm going to sentence you to 12 months. Those will be probated. Those will run consecutive to each other. So it's a total of 24 months probation. Special condition of probation is a fine of $750. That's it. No community service. This is going to impact your license however it impacts your license. The probation is a reporting process, meaning sort of like you've been doing with pretrial services. You may need to call in or something like that. Ms. Nelson, does Mr. Briney need to wait here for probation, or you will share with Mr. Fortis the contact information for that?
He needs to wait here, Judge, please.
Okay, so Mr. Briney, in just a few minutes, I'm going to get your sentence. I'll sign it. Once I've signed it, Ms. Nelson's going to call misdemeanor probation. They're going to come down here to this courtroom and they will meet with you, just get you signed up, let you know your first day that you have to report, and you'll be moving forward from there. I will offer you this. If you get to the 18-month mark of your probation and there are no issues, let Mr. Fortis know and he can reach out to me and maybe we'll suspend your probation a little bit early. No issues means no tickets. Obviously, no driving a truck full of fuel into overpass also. Okay?
And Judge, one point of clarification. We had agreed on a $500 fine. You said.
You had, I
$750.
said 750.
That's fine. I'm just making sure.
Yep. No, I heard the number and actually had written an even larger number. But then as I heard more about Mr. Briney's situation and how this played out and the zero criminal history, et cetera, I got to 750.
That's fine, Judge.
All right.
Making sure.
Mr. Jordan, anything else?
Nothing further from the Judge.
All right, Mr. Briney, good luck. Lighter feet on the pedals. Please wait out there and misdemeanor probation will come get you.
All right, thank you.
All right, and Mr. Fortis, I leave it to you whether you wait with Mr. Briney or not. They're not legal questions. They ask him, it's biographical. So you two sort that out.
Thank you, Judge, but that's all I have. That'd be excused.
Yes, sir.
Thank you. Good to see you as always.
Same.
So Judge, he'll wait in outside or would you rather?
No, wait in here. And the deputies knows who you are and also they know misdemeanor probation. So they'll know to connect the two of you. Okay?
Thank you, Judge.
You're welcome. All right. I need to read two short affidavits, which I'm going to read right here. Ms. Feely, I think you only had one, maybe two announcements to make. Are you ready for those announcements?
So Mr. Coleman will still be a plea.
Mr. Coleman, oh, but that was Ms. Wood's case, I thought. Maybe I'm wrong.
Number 4, Mr. Coleman is mine.
Is yours. All right, let me cross out Wood and write Feely. Okay.
And then position 2, Tony Clark, I thought I had a new offer, but it didn't get clearance. It doesn't sound like, so we are stuck with our same offer. So that one is just a ready announcement.
Okay, so Clark remains ready for trial.
Yes.
Is Clark, I gotta get all my notes in one place here. Let me put this in a safe place. Clark is our doctor in North Carolina, but we have a substitute doctor and we may yet get the doctor in North Carolina.
Yeah.
All right, so we're good with that. Not a plea, remains ready. Okay. So Coleman is a plea and that is your one plea for today. So that clears your docket. And your plea, Coleman, number 4 is with Ms. Willingham. Okay, so we could do that next if Ms. Wood is still shuttling around with others. So why don't we plan to do that? Let me read these two affidavits and get this agent on his way, and then we'll do the Coleman plea. Okay?
I never tried. Give my signal shot. All right, Officer Horton, you can come on up. So it's kind of hard to wiggle away from Instagram handle of Supercrit to say, no, I'm not in the game.
through these kinds of things? Good. One of your, is it McKesey?
Yeah.
He was back here and one of his is, it's just, he's working off of phones right now. He's a little ways behind, but he's hoping the phone gets him something else. Yeah.
That's a layered process.
Yeah. It's a start.
It's very fruitful though.
Yep.
We can figure it out.
Yeah. All right. You swear or affirm the contents of your affidavits are true and correct to the best of your belief and knowledge.
I do.
Good. You sign right there. Yeah. And it's some homework.
It's like, I know you, your mother and your.
Yeah. Hey, look at the one number that's talking to baby's mama and mom and girlfriend. It's gotta be who it is.
Exactly. All right, so that's that.
Yep, I'll reclip that for you. And then you sign that one. So we can bring Mr. Coleman out when you guys are ready, please.
Thank you, sir.
Cute. Appreciate it.
And, I'm taking this one, right?
Yeah, those are both yours.
Yes, sir. Have a good afternoon.
All right. Okay, I don't see Ms. Wood. She's what?
She's right outside.
Okay, great. Well, we'll get everyone in place and then if you could just get Ms. Wood to poke her head in before we start with Mr. Coleman. Hey, Ms. Nelson, somebody burst in here. Ms. Wood has something to tell you. We're about to take a plea in Mr. Coleman's case, but I'm happy to get an update from you first.
So, I guess I can do it after this plea. I wanted to let Ms. Nelson know in case I was in the hallway.
This is for you.
Position number 1.
Mr. Tripotis,
Hire. So we would need to have that conversation.
he is going to hire a lawyer
Yes.
for Monday.
Correct.
Okay.
And then he also has some other things that he wants to get on the record as well.
Well, let Mr. Tripotis, I don't see him in here. Oh, he's right there. Okay, great. We're going to take Mr. Coleman's plea and then we'll get what you want to share on the record, okay? Great. Okay. Ms. Taylor, you still good?
Yes, Your Honor. I just
Great.
had to, I'm still good.
Okay, good. Glad to hear it. This is position 4 on our trial calendar. It is State versus Rodriguez Coleman, 22 SC 180637. Mr. Coleman is represented by Ms. Feely. They are both up at the podium. Ms. Willingham is representing the state. Good afternoon, Mr. Coleman.
How you doing, Bates?
I'm okay. How are you doing?
All right, I'm in.
Good. Mr. Coleman, in a moment, Ms. Willingham is going to put you under oath. Once you're under oath, please answer her questions and mine truthfully. And please also let me or Ms. Feely or both of us know if you've got any questions of your own. I need to be comfortable that you're following what's going on. I have no reason to doubt that you won't. But if something comes up that surprises you or confuses you, you need to tell me or Ms. Feely that. Will you do that?
Yes, sir.
All right. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name, your age, and your date of birth.
Rodriguez Coleman.
You can put your hand down now.
My name is Rodriguez Coleman. I am 30 years old. Let me see what?
Your date of birth.
Oh, 08/06/1992.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
I attend college, year of college.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that count 1 will be reduced to battery family violence, OCGA 16-5-23.1, subsection F, subsection 2. 12, and the sentence would be 12 months to serve, 180 days. As to count as to count 2, you would plea as indicted for 12 months probation to run consecutive to count 1. Do you understand that negotiated
Yes, ma'am.
sentence? You are pleading guilty today to battery family violence with a minimum of 1 day and a maximum of 12 months, and simple battery with a minimum of 1 day and maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court that the negotiation in this case is 24 months to serve 180 days. Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 24 months to serve?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. Under the general conditions, you will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to complete family violence intervention program, no contact with the victim, complete a drug and alcohol evaluation, and follow any recommendations. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Most definitely.
Do you have any more questions for your lawyer before we go on?
Not at all.
Have you understood everything I've asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
On August 18th, 2021, Officer Burnside of the Sandy Spring Police Department was dispatched to 1001 Hunt Cliff Village Court, Sandy Springs, Georgia, in Fulton County.
You said what date? I'm sorry.
August 18th, 2021.
Okay, the indictment has October 15th, 2021. And the date is whatever the date was. I just don't want there to be a hiccup.
And Judge, I'll just double check the police report to
Okay.
make sure that I didn't put something in wrong. You're correct. It is October 15th of 2021. Regarding a domestic dispute. Upon arrival, Officer Burnside contacted the victim, Joya Robinson. During this contact, the officer noticed that the victim had redness on her cheek and neck, which was consistent with getting choked. As the officer spoke with the victim, she stated that she got into an argument with the defendant about her boyfriend, about him talking with other females, and told him that their relationship was over. Per her accounts, the defendant became irate and started yelling, which led to him attacking the victim. According to Ms. Robinson, the defendant jumped on top of her and began choking her with both hands. Upon release of her neck, she stated that he punched her in the face with a closed fist. Once she broke free from the defendant, she called 911 to report the incident, and the defendant immediately left the area via his vehicle. Are the facts of this case, as I previously told the court, generally true and accurate?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Are you on probation or parole for anything anywhere? I may have asked that already.
No.
Okay. That concludes the state's portion, Your Honor. I would, for the record, like to add that the state has had an opportunity to speak with the victim multiple times in this matter. Her biggest concern was that she believed, and this is just her belief, I cannot say whether it's fact or not, but that she believed that at the time the defendant was high or drunk on some substance, which is part of the reason the state wants the drug or alcohol evaluation done. Her biggest concern was that the defendant get treatment for whatever that was.
Okay. And that he have no contact with her. So they don't have
Yeah.
kids together. She is done with Mr. Coleman, which is frankly what she told him on October 15th. And she wants to maintain that I'm done with you status.
Correct.
Got it. Appreciate it. Let me turn to pretrial services. Ms. Jackson, can you share with me criminal history for Mr. Coleman, please?
The defendant has 5 cycles. The defendant's last arrest was August the 22nd, 2022, for a fugitive for justice in Memphis, Tennessee. And the defendant does not have any convictions listed in the GCIC. Nothing in addition.
Thank you. Ms. Tucson, do you have any criminal history for Mr. Coleman?
No, Judge, he's not on probation. No, files found within portal.
Okay, thank you so much. Ms. Feely.
Thank you. As the court heard, Mr. Coleman is 30 years old with no convictions and no other felony arrests. And so given his age, if this was something that was going to become a pattern for him, I believe it already would have. He has 3 children. He actually does have 1 child with Miss Strong. And I spoke with her as recently as last Wednesday.
You're saying Ms. Strong, and maybe she's changed her last name. I've got a Ms. Robinson.
So my understanding from her last week was that she wanted the no violent contact, but she certainly wanted his support with the shared child.
You've spoken with Ms. Robinson.
As of Wednesday, but the state she may have
Okay,
changed.
we'll clear it up.
Sure.
Okay.
This has been a very difficult situation, and he did do substantial amount of jail time. On initial arrest, he did 56 days, and since being picked up on the bench warrant, he's done 216 days for a total of 272 days. And I can put those dates on the record if I need to. But he did graduate high school. He studied electrical in college. He was most recently very gainfully employed as a forklift operator for the last year and a half. This is a case where my predecessor had been in contact with the complaining witness. Well, really vice versa. The complaining witness had contacted us. She's signed a waiver of prosecution. It's one of those types of situations and she's out of state. But Mr. Coleman is electing to resolve this way today. And so we are asking the court to accept the plea as negotiated.
Okay. Mr. Coleman, what's the Memphis, Tennessee connection? It sounds like when we finally caught back up with you, you were in Memphis and not in Atlanta. What's up there?
I have 2 kids there too, though.
Okay, so you've got 3 kids. One is local, well, may not be local anymore. It's wherever Ms. Robinson is. And then you've got 2 in Memphis. But your job with the forklift was here.
Right.
And home is here.
Right.
Okay. Have you been, I'm not asking this to get you in any more trouble. I'm just curious because I need to sort out how I leave your ability to have contact with Ms. Robinson. Have you had voice or written contact with Ms. Robinson while you've been in custody?
Say it one more time, Joe.
You've been locked up for about 6 months now. While you've been in jail, have you and Ms. Robinson communicated at all?
Yes, sir.
How does that happen? You call her?
She has set up visitations for me and then tell me how.
Meaning she'd actually come to the jail and visit with you, or she'd bring your kid to the jail, or it's video?
Video.
Okay.
Video. She sets it up. She pays for the video.
Okay.
We have contact.
And is that primarily you and Ms. Robinson talking, or is it you and your child talking?
Me and my child.
Okay. And the child you have with Ms. Robinson, boy or a girl?
Girl.
Girl, what's her name?
Alea.
Alea, how old is she?
She is now 9.
9. So she's grown up enough to know dad and want to talk to dad and all that stuff. All right. I think we've cleared all that up. Mr. Coleman, for you to officially plead guilty, you need to sign your indictment, but your indictment right now is just up on a screen, not a screen you can see, but do you authorize me or my staff to electronically sign the indictment for you, indicating your plea to the 2 misdemeanors?
Yes, sir.
Ms. Feely?
Yes, Your Honor.
And Ms. Willingham? Great, we will do that. Mr. Coleman, I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Knowing means you've understood everything people have been saying. Is that true?
Yes, sir.
Voluntary means no one's forcing you to do this, but you, after consulting with your lawyer, have decided this is how you want to move forward, correct?
Yes, sir.
All right. Ms. Willingham, it sounds like fairly recently, Ms. Robinson relayed, not to you, but to Ms. Feely, hey, I actually don't want Mr. Coleman 100% out of my life because Alea needs to spend time with him, and that means he's going to be communicating with me. So could it please be no violent contact? Do you have an objection to that being the condition, or have you, even more recently, as in the last couple of days, had Ms. Robinson tell you, I don't want Mr. Coleman within 1,000,000 miles of me?
The last time we spoke was last week. She still expressed at that time that no contact was fine. We went over what the state's offer was. I don't know if she, now based on hearing this, maybe she didn't understand that no contact is no contact.
Right.
But I do recognize that they have a child, so I would not have an objection. I would notify her, because obviously she's also spoken with Feely, so.
Right. Let's do this. I'm going to have the condition of probation be no violent contact. But if you speak with Ms. Robinson and she says, there's been a misunderstanding, I do not want Mr. Coleman contacting me, send an email to me and Ms. Feely, and I'll amend the sentence and it will say no contact at all. And if we're going to change that, we'll just have a hearing. We'll get Ms. Robinson virtually, and your client's going to be out of jail, so he can appear virtually and we'll work through it. But I think the default of no violent contact makes sense given Alea's situation, wanting to see her dad. But it sounds like Ms. Robinson's not even in Georgia anymore.
Correct.
So it should be the no violent contact, probably would be don't yell at me over the phone. How do you envision seeing Alea? Do you know where Ms. Robinson is?
No, sir. I can actually have my mom get in contact with her or my sister.
Okay.
And they can pretty much get my daughter for me.
Okay, so that will maintain the no violent contact. I think that's how we'll do it. If Ms. Robinson expresses alarm about that, let me know. And there may be a middle ground of no direct contact so that Mr. Coleman could call her to say, hey, we need to figure out a way that I can pick up Alea or she can come see me, whatever the deal is. But for now, we'll have it no violent contact.
Thank you.
You bet. Mr. Coleman, count 1 has been reduced to a misdemeanor. I'm sentencing you on count 1, which is family violence battery, to 12 months to serve 6 months with a balance on probation. You'll get credit for all the time you serve, which is more than 6 months. So you ought to be out by the end of the week. If you are not, reach out to Ms. Feely and she and I'll figure out if there's something else holding you in. Doesn't sound like it would be something else. And so then it should be something I can fix. Count 2 is family violence simple battery, and that'll be 12 months probation consecutive. So it's a total sentence of 24 months, 6 in jail, 18 on probation. You've already done 6 in jail, so you've got 18 months of probation ahead of you. Special condition of probation number 1, no violent contact with Ms. Robinson. Special condition number 2, you're going to complete what's known as a family violence intervention program. That is a series of classes, not just one, but a bunch, that'll help you navigate a situation like this in the future differently. Last condition I'll probably impose, but I want you to tell me, be honest with me, what was going on that day? Had you been drinking or smoking? And it's not getting you in any more trouble. It's helping me shape the sentence so that we're doing our best to make sure this never happens again to another Ms. Robinson.
Yes, sir. I was currently under the influence.
Okay. Then the final special condition of your probation is that you will submit to a drug and alcohol abuse evaluation. It's just where you'll meet with someone who knows the hallmarks of someone who drinks a little too much or smokes a little bit too much. If that person recommends treatment, that treatment becomes part of your probation. Okay. Ms. Feely, anything else for Mr. Coleman?
No, Your Honor.
Ms. Willingham? Ms. Nelson, does Mr. Coleman need to stay up here because misdemeanor probation will meet with someone in custody, or does this work a different way? Ms. Nelson may have stepped away from her desk. I just want to find, because I know they're here. They actually just showed up. Okay, okay, why don't you just keep them up for now? Mr. Coleman, it's possible that someone from misdemeanor probation is going to come meet with you right there in one of those little chairs so that you get they get your info. I assume you know where you're going to stay when you get out. So you'll be able to provide address and phone number and whatnot. It may be they don't meet with inmates. I don't know that answer. Here comes Ms. Nelson.
Okay, yes, you can leave him up in misdemeanor, we'll come and talk to him.
Great. So you're going to stay up here. I'm going to sign your sentence as soon as Ms. Nelson gets it to me, and someone's going to come right back there and get you all signed up. Okay.
Thanks.
Good luck with everything.
Have a good one.
All right, let's get Mr. Tripotis up to the podium, please, so we can get a few things on the record in his situation. Ms. Taylor, I need you to take this down, even though it's not a plea. Are you ready?
Yes, Your Honor, I'm ready.
Great, thank you. This is position 1 on the trial calendar, 16 SC 145311. Mr. Tripotis is currently represented by Ms. Wood. She is here in court along with her current client. And she, in Mr. Tripotis's presence, let me know that there may be a change in representation. So why don't you get on the record what you want to share with me, and then I will let you know what that means.
Okay.
I'm ready.
I expect by tomorrow to have obtained private counsel.
Okay.
I had not, up until this point, entertained the idea of private counsel because I had already spent a substantial amount of time in prison as a result of the conduct underlying this particular indictment specific to those vehicles, and had been punished for those exact vehicles in federal court. From the onset, you indicated that you worked in the United States Attorney's Office while this case was being assembled, and that you were familiar with it, and that if it got to the point where the state opted to pursue the case and it didn't get resolved and it proceeded to trial, that you would probably have to recuse yourself from the case because of your familiarity with myself and the case and history. I would expect that private counsel would probably motion the court to have it assigned to a different judge. Although I wouldn't have a problem with you being the judge. You know, I like your demeanor and your personality, and I see you on TV all the time. It's exciting to see you in person.
Here I am.
And your resume with the BMF case and things of that nature. So be it as it may, it is quite disheartening that the state would opt to pursue this case in light of the fact that I've spent more than 6 years in prison and am now employed as a litigation specialist for a law office and have engaged with media outlets to do programs that will be aired soon, teaching the public how not to be victims of auto theft.
Victims of your prior conduct.
Of the things that I set in motion years before.
Sure.
Technology has changed so that it makes it extremely easy for people, citizens, to be victimized. So it's quite a conundrum for me to be engaging with Randy Travis, for example, to help Georgia citizens in the state to not become victims of things that I used to do, while simultaneously being prosecuted by the state or by society.
For things that you used to do.
Precisely.
Okay, so I'm following you. Let me ask one question and then share a few things. Do you already have an attorney in mind, or you're going to get over here and white pages, got to call someone?
No, I've been in communications with Bruce Harvey.
Okay.
And we're set to communicate this afternoon. Well, it is this afternoon.
It is?
Probably after I leave here.
Okay.
At his office on Nassau Street.
So it's good you have someone in mind, and it sounds like you are determined and you've got the financial ability to make that happen. In terms of recusal, I don't recall saying I would. What I recall saying is we'd have to see more about the nature of this case and where it went. That'll be a good conversation for you and Mr. Harvey to have. He and I know each other well also, both from my time as a federal prosecutor and then my time here. So he'll have some thoughts about the wisdom of, leave it with McBurney versus, well, given his prior connection to you and maybe the facts of this case, I still don't know how overlapping this is with what was going on with the FBI. And we don't need to sort that out today. Importantly, Mr. Harvey will be in a good position to do something like that. He does federal practice as well. And so he may be well suited to help the district attorney's office to see if this is overlapping prosecution or distinct prosecution. He will tell you, because he is a very smart lawyer, that the DA's office has the authority to re-prosecute someone for the same conduct because they are what they call separate sovereigns. It's harder for the feds to do it because there is a written policy in place that you need to get approval from Washington to go after someone who's already been prosecuted at the state level. Your bad luck is it's going in reverse order and the feds went first. Typically the state doesn't go somewhere where the feds did, but I am taking you at your word that there's overlap here. My vague recollection was that you had your tentacles in a lot of things and the FBI said, we're just going to draw a box right here and focus on that. And so they may have left some things on the table and that may be what the state picked up. Now isn't the time for you and I to have an exchange, for you and me to have an exchange about that. But Mr. Harvey can help you navigate that. The important thing for you to tell Mr. Harvey is that you are on a trial calendar for Monday. And so the fact that he is a busy guy and is handling the YSL trial doesn't necessarily give you a ripcord to spring out of Monday's deadline. However, if Mr. Harvey somehow has the resources, maybe through associates, to engage the state between now and then to say, I think there are these pieces that you ought to consider, and this could be a duplicative prosecution, et cetera, I'm open to hearing about that. It just, you need to be mindful of the clock that's ticking, because at a minimum, you'll be back here on Monday morning. Mr. Harvey, maybe, maybe not. If he's your lawyer and he's not there, I can't make you go forward with him not there. But you just need to let him know where we are in the process. It's not day one, you just got indicted, and you got indicted 7 years ago. But it is closer to trial time than brand new case.
Well, I did, and I think the court's aware, and everyone's aware, even the public defender's office, that I had zealously attempted to be brought back before this court for 7 entire years.
Yep.
And when I was released from federal custody, the warrant was not active.
I understand.
I brought myself into the courtroom and said, take me to jail so I can get this case over with.
Yep. No, you have been at the forefront throughout. So my point wasn't it's your fault that it's an old indictment. It's just that Mr. Harvey would need to understand that you actually got a hot date on Monday for a trial. And so he will have thoughts about, hey, I can manage that or I can't manage that. What I'll need to see is the entry of appearance of some lawyer before Monday, because otherwise Ms. Wood remains your lawyer unless you are your own lawyer. And you are smart enough, I believe, that you appreciate the lack of wisdom behind self-representation. So it sounds like you are going to reach out to folks and see what you can do. I'm telling you now, yours is one of the cases that'll need to be here on Monday. So you should be here on Monday unless a lawyer you've hired who's filed an entry of appearance says, whoop, I got word from the judge, we're off because of ABC. There are 100 reasons why it might be off. Okay?
Yes, sir.
I feel like you understand it. Ms. Wood, is there anything else you want us to get on the record since you remain attorney of record for Mr. Trapadas?
Yes, Judge. So I'm just thinking of all my other cases that are also on Monday's trial calendar.
I don't expect you to prepare for it. Mr. Trapadas has very respectfully said he's going to replace you with a hired attorney, his right. And he seems to be of sufficient means that he's going to be able to hire someone. If it's not Bruce Harvey, Mr. Harvey may have recommendations that Mr. Trapadas could pursue. So Mr. Trapadas needs to be thinking about getting ready for trial. And more importantly, the lawyer he hires needs to be thinking about that or a way out of a trial date on Monday. Okay? All right. Mr. Jordan, anything you want to get on the record? Okay. So you'll want to, Mr. Trapadas, make sure you've got Mr. Jordan's name because the lawyer you hire is going to say, well, who am I dealing with? And it's Julian Jordan. Okay?
Nice to meet you.
All right.
Thank you, sir.
You bet. Wow, that was fast, Mr. Jordan. There's the null pros, as promised. Okay, Ms. Wood, I think it's your afternoon now.
Judge, I have some announcements and then I do have pleas ready to go.
Okay, let me see here. Yes, I'm ready for your announcements.
Okay, position 11 and 12, Baxter Ross would like to go to trial.
Okay, Mr. Ross, there he is. Great. Mr. Ross, you've got two cases. One charges you with robbery and some other things, and one charges you with aggravated assault and some other things. The state tells me that your robbery case is the one that will go out first. Ms. Wood will be ready on both, but she'll focus on the robbery case because that's what the state gets to pick which one of the two they're going to do. So that's the one that I will have on my list for Monday. You need to stay in touch with Ms. Wood. She'll confirm that you need to be here Monday. We've got a few more moving parts here, but assuming that the other pleas that I've got on my list go forward, we will likely be bringing your case in as one of the ones for Monday. Okay? Any questions about that? You can be here 9 a.m. on Monday? Great. Do you need Mr. Ross to stick around?
No, Your Honor.
Okay, thank you.
Position 14, Mr. Swanson also is going to be a trial.
Hold on one sec. Before we get into Mr. Swanson's situation, I've heard some noise about a possible mistrial down in 1D. Are you guys hearing anything about that?
With 88 Hall.
That's the case.
I have not heard that.
Okay, you're not going to know if there's a mistrial down in 1D. Okay, just hold on one sec. I'm just flagging that because that affects what Monday will look. I mean, if there's a mistrial, that case cannot spill over into Monday. And so then you are in that dilemma of maybe needing to be in two different places. Okay.
Thank you, Your Honor. I
Sure.
appreciate that.
All right. If you guys can get any intel on that and share it with me, that'd be great. Okay. Mr. Swanson was wanting to get your attention. You want to talk to me or you want to talk to Ms. Wood?
Ask you something on my behalf, Your Honor.
She may be about to do that.
I didn't get it, but I'm happy to talk to him and make my other announcements.
Okay.
Text me? Okay.
So we'll hold on Mr. Swanson. And then we've got, who else?
Position 23, James Robinson,
Yes.
also a trial.
That is Mr. Hiles's case. This is the FMLA witness.
Yes, Judge.
Okay. Robinson, and that was on your list of one you're ready to do.
Yes.
Okay, so I got that. So Mr. Robinson, I will be letting Ms. Wood know which of her cases need to be here on Monday morning. And it may be that you get bumped down a little bit because some of the older cases are now saying, I want a trial, like the gentleman who just left. So just wait for word from Ms. Wood and she'll let you know if you need to be here on Monday or not. Does that make sense? Any questions? Do you need him to stay?
No, Your Honor.
All right. Other announcements.
I'm ready on Mr. Jaluk and Mr. Tate's plea. I did want to speak with Mr. Hooley one more time.
Okay.
But otherwise, I'm ready to go.
All right. Well, why don't I just go in numerical order? We'll do Mr. Tate. Unless, do you want to do Mr. Dixon? Because that will free up. I'm fine. I guess Willingham and Shapiro should arm wrestle on this one.
And Judge, did you want me to speak to Mr. Swanson?
I do. I just want to know what we're doing next, and then we'll get that moving. Oh, why don't we do that? Well, if we did Shapiro, oh, that doesn't free you up. They're all your cases.
Right. If Miss Feely comes back, I can have her stand in.
Okay. Why don't you talk with Mr. Swanson? It may not be a long conversation. Sure.
I'll make it. Last. Just to make sure.
Give me 1 second.
No worries.
Okay, so you were giving me an update on position 14, Mr. Swanson. You had made a counter offer on his behalf. Where are we with that?
It was rejected.
Oh, okay.
I spoke with Mr. Swanson again, Judge. I do apologize. It slipped my mind when I was saying I was ready for trial. This is the case where the body cameras are missing.
This is why, because maybe it was going to work out, I got less worried about it. But Mr. Jordan said it's still a College Park case. Okay. And so there is evidence that could be exculpatory.
Correct. From speaking with Mr. Swanson.
Okay. And just remind me of what it would, I'm just looking at these charges here. Like, was a car pulled over?
Car, another person involved.
Okay. So we need to see. And it could also resolve the case I mean, it could be something where Mr. Swanson sees that video and says, boy, I better take that offer.
Yes, Judge.
Okay, got it. And this is College Park we have no idea when we'll have this footage, Fane.
No ETA yet, Your Honor. I will make sure to have my investigator reach out again, since it's been about a month since I got that update to see if there's a current ETA. But my understanding is that they're changing programs, that they have no ETA on when they're going to be able to access body cam before June of this year.
Okay, all right. Mr. Swanson, it was good to bring that up. And your lawyer actually had pressed that before. She just, it didn't come up at this point, but I had a long conversation, actually directed the prosecutor to get me written proof that really College Park can't get us body cam footage. And that is the sad state of affairs down there, that they are moving to a new system, and whatever planning they did, they currently can't get any old body cam footage. So it's not appropriate to move your case forward until both sides have had a chance to look at it, because it may be real helpful to your case. And based on that, Mr. Jordan may accept the counteroffer. It may be after Ms. Wood looks at it, she looks at you in a different way and says, you should be lucky they're not trying to send you to prison for 5 years. We'll all need to look at it, okay? Do you need Mr. Swanson to stick around?
No, Your Honor.
Okay, did you get something in the mail to be here today?
No, Your Honor, I spoke with Ms. Wood personally over the phone. I did want to add that I'm the sole caregiver for my child, and I've been going through stuff with defects, child care services. I don't really have anybody else to parents, but she's currently outside with my friend while they're waiting on me in the parking lot.
Okay.
She was making noise that early.
That's okay. It was cute noises. It just, we couldn't hear what was going on. I don't want you to not take care of your kid, but why are you sharing that with me? Like, you just don't want to have to come down to court again until you absolutely need to?
It really was more for, I was trying to talk to the DA, so I could, cause I got the offer, but it was last minute. I got the court date kind of last minute. I really haven't got a chance to really talk about too much of anything.
Okay. Well, guess what? More time has been added to the equation. And so Ms. Wood will make it a point to spend some time with you, maybe when your kid's not running around pulling on your elbow, to have a heart-to-heart about what's going on. My guess is it makes sense to wait until that body cam footage is there. And so in the meantime, you're going to be able to go about your business, take care of your kid, work. Assuming that's why you've got the Delta vest or whatever that is. But I'm concerned that you didn't get anything in the mail. I got a funky address for you. It says 1001 Hunt Cliff. All right, so we've got a change of address form here. Deputy Gordon's going to give that to you. Please fill that out with all your phone number, address, et cetera, so we can get it in the system. More importantly, Ms. Wood knows how to reach you, but we need to be able to get something in the mail to you, okay? All right, after you filled that out, you're free to go. Ms. Wood will be in touch with you. All right, so we got those updates and now we can go forward with a plea.
Yes, Judge.
Okay, I was gonna say, let's just go down numerically, so it was gonna be Tate next. If you need to talk with Mr. Hewley
Ms. Feely is gonna stand in on that.
on the Hewley situation or the Tate?
I'll take Tate and she can speak to Mr. Hewley.
Great, let's do that. Mr. Tate, you here? Can you come on up, please? This is position 19. Another strangulation. Thank you. Hope it's legible. 2966 Fields Drive. Give me 1 second. Okay, everyone ready?
Yes, Judge. Yes, Your Honor.
Great. Position 19, State versus Mike Tate, 22 SC 184132. Good afternoon, Mr. Tate.
Good afternoon, yeah.
How are you?
Already?
Good.
Yes.
Are you okay standing for this?
Yes, I'm okay.
Great. Mr. Tate, in a moment, Ms. Willingham's going to put you under oath. When you're under oath, make sure you answer her questions truthfully, okay?
Yes, sir.
And will you let me know if there's something you can't hear or something you don't understand?
Yes, sir.
Great. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, yes.
Please state your name, your age, and your date of birth.
Mike Tate, 3/20/66, 57.
So how old does that make you?
57.
Okay.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am, I take high blood pressure medicine and cholesterol medicine.
And does that medicine cause you to have any altered mental state?
Well, sometimes I feel a little dizzy sometimes, every now and then.
But not so that you wouldn't understand what we're doing today?
No, it wouldn't.
Okay.
If you get dizzy, let me know.
How far did you go in school?
12th grade,
Can you read and write in the English language?
yes.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am, it would when I'm with him.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that count 3 of the indictment will be null prized. And as to counts 1 and 2, You will be sentenced to 5 years probation to suspend after the completion of family violence intervention program, have no violent contact with the victim, no drugs or alcohol, and be subject to random screenings, no weapons, and Your Honor, originally part of the negotiation was complete 20 hours of community service. I will leave that to the court, but I do want, just for the record, to recognize that I do recognize there may be some in terms of movement, so I will leave it to the court.
Okay. There are lots of community service opportunities
There
where
are.
you don't have to carry heavy objects long distances.
There are, I just wanted to let the court know one way or the other,
Okay.
that if that was, I would obviously have no objection.
All right. You wouldn't appeal?
No, Judge.
Okay.
You are pleading guilty today to aggravated assault, strangulation, and aggravated assault, family violence. Both charges are family violence charges, and they carry a minimum of 3 years and a maximum of 20 years. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court that the negotiation in this case is 5 years probation to suspend after completion of family violence intervention program. Do you understand that the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 20 years?
Yes, ma'am.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including, but not limited to, that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you are to complete family violence intervention program, no violent contact with the victim, no drugs or alcohol, subject to random screening, no weapons, and to complete 20 hours of community service. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I asked you so far?
Yes, ma'am.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, ma'am.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am. Yes.
On October 2nd, 2020, Officer A. Rutherford was sent to a call at 1536 Westwood Avenue Southwest, Atlanta, Georgia, Fulton County. Upon his arrival, he made contact with Miss Elise Kopich. Miss Kopich stated she was riding with her boyfriend, Mike Tate, and another female only known as Kiki. Miss Kopich stated that she got into a verbal dispute with the female over the female smoking in the car. Miss Tate, who was under the influence of alcohol, according to Mr. Tate, who was under the influence of alcohol, according to Miss Kopich, got angry at her for telling Kiki not to smoke in his car. Mr. Tate reached over from where he was seated in the driver's seat of the vehicle and began to choke Miss Kopich with his right hand by grabbing her around the neck and squeezing tightly, making it difficult for her to breathe. Miss Kopich advised that at a red light at the intersection of Donnelly Avenue and Cascade, when this occurred, they then drove through the light onto Westwood Avenue, and Mr. Tate continued to choke her. While Mr. Tate was choking her, Kiki, who was in the back seat, grabbed her face. Mr. Tate stopped the vehicle in front of 1563 Westwood Avenue, just before the intersection of Westwood Avenue and Ontario Ave. Mr. Tate got out of the driver's seat of the vehicle and walked to the front passenger door, where he opened the door and threw out Miss Kopich into the street. Are the facts of this case, as I previously told the court, generally true and accurate?
Yes, but it didn't happen like that.
And Mr. Tate, there'll be a point in this conversation where I ask you to share with me your thoughts about this. But what I'm understanding from Ms. Willingham is that can you spell the
Yes.
victim's name?
Coppage.
I'm gonna call her Coppage because they're two P's, but if you've talked to her and she says Coppage, I better go by that. Does she say Coppage?
She said Coppage.
Well, she's the boss. So if Ms. Coppage were to testify at a trial and she were to say you did these things, that while you were driving, you were somehow choking her, and then you got out and you threw her to the ground, a jury could believe her. And if they believed her, they could find you guilty of these crimes. So I'm not saying that's exactly how it went down, but if that's how Ms. Coppage remembers it, and that's what she told the jury, and they believe her and not you, that could be a problem. You understand?
Yes, sir. Yeah.
Okay. Is that why you're going forward with the plea?
Yes, sir. I mean, it's been many years ago, and
It has been many years ago.
And like I said, two females, they got into it, and I just did. I was driving, I got upset, so I thought I was doing the right thing, trying to get them out of my vehicle and try to save peace.
Okay. So it sounds like there are some commonalities between your recollection and Ms. Coppage's. You were trying to get him out of the
Now, if you
car.
can imagine yourself, you drive and you got folks fighting across the street, go driving, I'm getting upset. Hey, don't,
Yep. Okay, I follow you. I'm sorry we interrupted you, Ms. Willingham. I just wanted to, given Mr. Tate's hesitancy when you asked that question, I think I now understand why we are where we are.
Judge, I was actually going to stop there as well, so
Okay.
it worked out perfect.
Perfect timing. Okay.
Are you a United States citizen?
Yes, ma'am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition. You have 4 years from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, ma'am.
Do you understand that you are not allowed to possess firearms during the course of your probation?
Yes, ma'am.
Do you understand if you are found in possession of a firearm, you could be charged with another felony, which carries up to 10 years in confinement?
Yes, ma'am.
Your Honor, we recognize the facts of this case that the state has read. We have had an opportunity to speak with the victim.
Ms. Coppage.
Yes, and per my last conversation with her, they were soon to get married.
Ms. Coppage told you relatively recently, I plan on marrying Mr. Tate.
Yes, Your Honor.
Well, what a happy ending to a bumpy story from 2.5 years ago. Okay. Thank you for sharing that. Let me get a little more information about you, Mr. Tate, before I turn to you. Ms. Jackson, can you share with me, please, what you have for criminal history?
Yes, Your Honor. The defendant has 15 cycles. The defendant's last arrest was July the 18th, 1999, with the City of Atlanta Police Department for a battery. There was no disposition for that arrest. The defendant does have one prior felony conviction. It's in 1998 for aggravated assault. And the defendant has misdemeanor convictions. It's in 1996 out of Wilkes County for a DUI, and one in 1992 for a DUI. Additional one in 1992 for carrying a concealed weapon and carrying a pistol without a license, and simple assault. Nothing in addition, Your Honor.
Thank you, ma'am. I appreciate it. Ms. Wood.
Thank you, Judge. He is 57 years old. He's a lifelong resident of Georgia. He served 29 days on this case, and he gainfully employed at Grady for 20 years. He was gainfully employed for Fulton County for 25 years. He's currently retired. He works part-time at the airport as a custodian. It is correct. He and Ms. Coppage, they are engaged and they are looking forward to getting married soon. That is actually one of the reasons he was eager to plead, so that this is behind him and they can have contact again.
Because it's a condition of bond.
Yes, Judge.
Got it.
What he's already put on the record, he maintains there was a squabble in the car. There were other people in the car. I think alcohol played a factor as well. He understands, and our office did talk to Ms. Coppage, and she's ready to move forward as well. So we just ask that you accept the state's recommendation.
All right. Mr. Tate, what did you do at Grady?
Well, I did various jobs. I was a gardener, utility on call, and whatever they call for, et cetera. I did a whole bunch of jobs at Grady.
Grady has a garden?
A gardener. I used to cut the grass, cut the grass.
Yeah. Where are there lawns at Grady?
Well, the old Grady did. They had a little grass, and I ran what you call incinerator too.
Okay. Interesting. And what'd you do for Fulton County?
A
lot of
I
jobs.
worked with community service peoples, general maintenance, traffic department.
A lot of different things.
I did a whole lot for the county.
All right. Mr. Tate, do you authorize my staff to sign the indictment for you indicating your guilty plea? We've got an electronic version back in my office that we're going to sign. Is it okay if we sign for you?
Yes, sir. Yeah.
All right, Ms. Wood
Yes, Judge.
and Ms. Willingham.
Yes, Your Honor.
All right, Mr. Tate, I am going to accept your plea. I find there's a factual basis for it. I understand there's a dispute as to what exactly went down in that car and outside that car in October of 2020. But as I told you when we talked just a few moments ago, if Ms. Copage continued to tell a jury what she told the police, which got to Ms. Willingham, a jury could find that you did the things that she alleges. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to go forward. You're eager to move on and you've decided this is the right way forward. Is that correct?
Yes, sir. Yeah.
Okay. And a knowing plea just means you've understood everything we talked about. Do you agree with that?
Yes, sir. Yeah.
Okay. I'm going to sentence you under the Probation Options Management Act. And all that means is that while you're on probation, if you have a small problem, a technical violation, you and probation will work through that. I don't have to get involved. But if it's more serious, you get arrested again, or anything to do with you touching Ms. Copage in the wrong way, that comes back to me, and then we'll work through that. Okay? I see you shaking your head. You're 57, no more
You don't have
arrests.
to worry about me no more.
All right, good. I don't want to worry about you. I don't actually worry about you, but it'd be good if I don't have to. Mr. Tate, I'm going to sentence you on count 1 to 3 years and count 2 to 3 years. Those will run concurrently with each other and they will be probated. So it's 3 years probation. Special condition of probation number 1 is no violent contact with Ms. Copage. Special condition number 2 is that you complete a family violence intervention program, which is a series of classes that'll help you work through a situation like you found yourself in with those 2 women fighting in your car in a different way. Maybe you just make them get out themselves, but you don't lay your hands on either of them. You will also be subject to at least 2 random drug and alcohol screens a month while you're on probation. And you will have 20 hours of community service to take care of over those first few months. You don't have to do it all in one weekend, but do take care of it up front, because I am setting a behavioral incentive date of, let me look at a calendar here. Of October 18th, 2024, which is about a year and a half from now. So you get halfway through that probation, you've taken care of the family violence intervention program, your community service, haven't been drinking too much, then maybe they'll end your probation early. Okay?
Yes, I am.
All right. I think I covered everything. Ms. Tucson, any probation reporting instructions for Mike Tate?
Hi, good afternoon. Mr. Tate, may I have a phone number for you, and what county do you live in at the moment?
Yes, ma'am. Happy Wednesday to you.
Happy Wednesday.
Live in Fulton County. My
Okay.
phone number is 678-973-5153.
678-973-5153.
Copy.
Okay, I will give you a call. Does Ms. Wood have your mailing address, or you could also give it to me as well?
1995 Shirley, like the lady Shirley Street, Southwest, Atlanta, Georgia, 30311.
Okay, and are you familiar with where probation is in Fulton County on 276 Memorial Drive?
No, ma'am, but it shouldn't be hard to find, so I can get started and get things heading the trend in the right direction.
Okay, I'm gonna have you reporting on April 27th. Okay,
Yes, ma'am.
and that's gonna be at 10 a.m. But I will also call you to confirm these reporting instructions. Failure to report will result in a warrant, okay?
Yes, ma'am.
If you have any questions, you can give me a call and I will send you my phone number.
Yes, ma'am. Thanks for the hard work and have a great day.
Thanks, you too.
Okay, just call me.
And you can call me if you have any questions. It's right down the road from here.
Oh, ain't no number.
No, but you can call my number and I can get it for you, okay? Thank you, Judge.
You're welcome, Mr. Tate. Good luck.
Yes, sir. Yeah, thank you too. You have a great rest of your day.
I hope to take a few more, please.
You're welcome.
So I count 3 remaining: Hewley, Jaluk, and Dixon.
Sure, that's fine. Can we do Jaluk next, Judge?
We sure can. That's number 22. Ms. Willingham, you ready? Just as you were getting comfortable. Get back up there.
And Judge, I can make an announcement on position 10, Mr. Hewley.
Before you do, hold on once. Oh, let's do that first. Yes.
This is no longer a plea today, Judge.
Okay. We don't need to get it on the record, but I do want to engage with Mr. Hewley. Mr. Hewley, how you doing? So you are never obligated to take a plea. That's not anything that's required. It is a way to resolve a case. I want to make sure you understand that if you don't resolve your case today, I will likely see you on Monday for trial. Let me understand what the offer is right now. You may need to grab a different purple folder because you may be looking at a slightly different landscape on Monday. And I just don't want you to say, Judge, I'm surprised. What happened? So let me just hear what the situation is. So if Mr. Hewley were to plead today, what would the state be recommending?
Your Honor, counts 1 and 3 would be non-pressed. And as to counts 2, 4, and 5, there would be it would be a sentence of 12 months as to each count, and each of those would run consecutive.
So the felony would go away. Mr. Hewley would be pleading to only misdemeanors, and your recommendation would be 36 months of probation.
Correct, Your Honor.
Okay, got it. So Mr. Hewley, you understand that a plea today, if you were going to do it, is just misdemeanors, no felony. That's the biggest thing that's going to be different come Monday. If you go to trial and you're found guilty, I'm not saying I know nothing about the case. This may be the worst case ever and the state could never prove it. But let's assume for a minute that there's a little traction to it. Sounds like it's going to involve kids. Jurors don't like bad things happening to kids. If they think you did something bad to kids and they find you guilty, count 1, a felony, that's big. That could mean prison in terms of years and not months. I'm not saying that would be your sentence, but I just want you to assure me you understand that's a very different setting if we go to trial on Monday. There's a felony count in there, all 4 misdemeanors. Whatever the allegations are, they're going to get in front of a jury. It's not just you and me and the lawyers, but it's 12 folks probably hearing from some kids who I'm guessing are important in your life because they were around you and you were around them. You understand how it would be different next week?
Yes, sir.
Okay, understanding all that, you're not interested in pursuing pleas just to misdemeanors. Okay, last thing, Ms. Willingham, the offer to plead to misdemeanors, does that expire when Mr. Hewley walks out the door?
Yes, Your Honor.
Okay, great. So I get it. You understand it. You are saying no, thank you, which is your right, to the offer. You will plan on being here on Monday. Ms. Wood will get you an email, but I'm guessing since you're number 10 on the calendar, that's pretty high up, as in one of the ones we'll likely reach, that you need to be here on Monday, ready to go. And the trial will probably take a few days. So you need to be here Monday, Tuesday, let's say at least through Wednesday, helping your lawyer defend these charges.
I know how it
Okay, I'm not talking down to you. I just don't, what I don't like is that I get here on Monday and all of a sudden, Mr. Hewley's got these big eyes. No one told me what, a jury and a felony. And so I'm not trying to talk down to you in any way. I just don't want us to have that conversation on Monday with Judge. No, it'll be, yep, you told me. I'm ready to roll. As long as you're not telling me about the facts of your case, you're welcome to tell me something.
I'm gonna say for the similar to the best of the case.
Okay, Ms. Wood is giving you the advice of zip it. All right, sounds good. I will see you on Monday. Do you want Mr. Hewley to stick around?
No, Your Honor.
Okay, all right.
This is concluded. I believe Ms. Wood has this under control, if I may be excused for the day.
Well, let me ask, Ms. Wood, you okay if Ms. Feely ghosts you?
I just have Mr. Jaluk, and then I'm so sorry, Mr. Shapiro. I just need to speak to Mr. Dixon very briefly after this.
Okay, all right. I think it looks like he's getting work done, so he's okay. Okay, great. Okay, Mr. Jaluk, you're very patient. Thank you for standing there.
No problem.
All right, let's turn to position 22. It is State versus Bruce Jaluk, 22 SC 184222. Mr. Jaluk is represented by Ms. Wood, who is here with him, and Ms. Willingham represents the state. Mr. Jaluk, you'll be put under oath in a moment. You've now watched several pleas today, so I think you know how it's going to flow. Make sure you provide truthful answers, and also please let me or your lawyer know if you've got any questions, okay?
Sir.
All right, when you are ready, Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Please state your name, your age, and your date of birth.
My name is Bruce Dorian Jaluk. I'm 36 years old. My birthday is March 24th, 1987.
Are you now under the influence of any medicine, drugs, or alcohol?
No, ma'am.
How far did you go in school?
12th grade.
Can you read and write in the English language?
Yes, ma'am.
Have you had the opportunity to review the document that charges you in this case?
Yes, ma'am.
Do you fully understand the nature of the charges pending against you?
Yes, ma'am.
By pleading guilty today, you are giving up certain rights. The right to a trial by jury, the right to be presumed innocent, the right to confront any witnesses that may testify against you, the right to subpoena any witnesses for your defense, the right to testify yourself and to offer any other evidence in your defense, the right to have an attorney to assist you throughout the trial proceedings, and the right to not incriminate yourself. Do you understand these rights?
Yes, ma'am.
Do you understand that if you were to plead not guilty or remain silent and enter no plea at all, the state would be required to have a trial on these charges by jury?
Yes, ma'am.
The negotiation in this case is that counts 1 and 2 will both be reduced to misdemeanor family violence, OCGA 16-5-23.1, subsection F, subsection 2, with 12 months to serve 5 months with credit for time served as to count 1, with the balance probated, and as to count 2, 12 months probation consecutive to count 1, and counts 3, 4, and 5 will be non-pros. You are pleading guilty today to 2 counts of misdemeanor battery family violence, each with a minimum of 1 day and a maximum of 12 months. Are you now serving any other sentence in confinement, or are you on probation or parole for anything, anywhere?
No, ma'am.
You heard me tell the court that the negotiation in this case is 24 months to serve 5 months with the balance probated. Do you understand the court is not required to follow that recommendation, but can sentence you up to the maximum sentence permitted by law, which is 24 months to serve? Do you understand that?
Yes, ma'am.
Do you further understand that you may not withdraw your plea once the court pronounces sentence?
Yes, ma'am.
Should the court sentence include a period of probation, you will be required to obey both general conditions of probation and special conditions of probation. You will be required to follow the general conditions of probation that probation will give to you when you meet with them, including but not limited to that you are not to violate the criminal laws of any governmental unit. Under the special conditions, you're to have no violent contact with the victim, Tracy Hollis, and to complete family violence intervention program. Do you understand that a violation of any of these conditions could lead to a revocation of your probation?
Yes, ma'am.
Are you entering your plea of guilty with an understanding of everything we just talked about?
Yes, ma'am.
Has anyone used any force, threats, or promises which caused you to plead guilty against your will?
No, ma'am.
Are you satisfied with what your lawyer has done for you in this case?
Yes, ma'am.
Do you have any more questions for your lawyer before we go on?
No, ma'am.
Have you understood everything I have asked you so far?
Yes, I do. Yes.
Understanding all of your rights, do you wish to enter a plea to these charges today?
Yes, ma'am.
Is your decision to plead guilty made freely and voluntarily?
Yes, it is.
Did you in fact commit the offenses to which you are pleading guilty?
Yes, ma'am.
On August 18th, 2020, at 1685 MLK Junior Drive, Atlanta, Georgia, Fulton County, Tracy Hollis reported that she had a verbal altercation with her current boyfriend, Bruce Jaluk, over her ex-boyfriend visiting Ms. Hollis at home. Ms. Hollis stated Jaluk was angry and drinking and breaking items in the house. She offered to take Jaluk to his friend's house. While in the vehicle, Jaluk hit Ms. Hollis with a tray, causing a fracture to Ms. Hollis's nose, bruising around her left eye. Jaluk exited the vehicle, racked the slide. Sorry, that's it. Are the facts of this case as previously told?
Sound like you were gonna get to something real dramatic about a gun. You're walking that back?
Well, Judge, I actually don't know how I wrote it. So it was more so not, just wanted to leave it out, but it's not written.
Okay, the main thing is busting the nose with a tray.
Correct.
Okay,
Are the facts of this case, as I previously told the court, generally true and accurate?
Yes, ma'am.
so Mr. Hold on, Mr. Jaluk, you don't need to say yes if there's a big dispute.
Well, I mean,
If you smacked Ms. Hollis and you were drunk, then generally it's correct. If you weren't there, you hadn't been drinking anything, you were treating her all lovey-dovey, then hey, that's it. I didn't get rough with her.
well, I'm pleading guilty to what I'm charged with.
Okay, got it.
Are you a United States citizen?
Yes, ma'am, I am.
If you wish to challenge this plea for legal error, you have one of two ways to do it. Your lawyer can explain what these ways are and how they work, but I must advise you of some time limits. The first way is a direct appeal. You have 30 days from the date the sentence is entered to file this appeal. The second way is a habeas corpus petition, and you will have 12 months from the date the sentence is entered to file this petition. Do you understand these time limits?
Yes, I do.
Your Honor, the state has had an opportunity to speak with Ms. Hollis. We actually last spoke on Saturday. And the family was actually together.
Family meaning Mr. Jaluk and Ms. Hollis.
Per my conversation with her, yes.
Okay.
So she does not wish to move forward. The state worked diligently to try and kind of get this actually going forward, but we've done all we can to work with Ms. Hollis. So that is why we reached the resolution we did.
Okay. I think we had hints of this coming because I saw that I modified the bond for Mr. Jaluk that let him, I think, reside with her. And it was just no violent contact. So I guess she, for whether it's romantic or economic or both reasons, she's been pushing for a while for this to not be an obstacle.
Yes, Judge, she has.
Okay. All right. Got it. Ms. Jackson, can you share with me any criminal history information you have, please?
Defendant has 6 cycles. Defendant's last arrest was July the 24th, 2012 in Clayton County for a probation violation. The underlying charges were criminal trespassing and driving without a valid license. The defendant does have a misdemeanor sentence and a misdemeanor conviction. The defendant received a nolo contendere sentence in 2011 out of Clayton County for driving without a valid license. And there was one in 2011 out of Clayton County for criminal trespassing. Nothing in addition, Your Honor.
All right. Thank you. Ms. Wood.
Thank you, Judge. This is an August 2020 incident. Ms. Hollis started contacting our office immediately once he was arrested for this case. She has spoken with our office numerous times. She first wrote her statement saying that this was all just kind of out of proportion in October of last year. When she spoke to my office, she informed my investigator that alcohol was involved. She was drinking as well as Mr. Jaluk. She even said, I don't know, I may have hit him first.
With a tray?
A whole thing, Judge.
Okay.
It was a whole ordeal. She's been advocating on his behalf the whole time I've had the case. And so they are eager to put this behind them and move forward. He's 35. He's originally from New Orleans. He's lived here for the past 15 years. He has 4 children. He does have a 12th grade education. He does have his GED. He's gainfully employed. And we would just ask that you accept the state's recommendation.
Mr. Jaluk, of your 4 kids, are any of them with Ms. Hollis?
No, ma'am. No, sir. I'm sorry.
Okay. Do any of them live with you and Ms. Hollis?
No, sir.
Do they all live back in New Orleans?
No, sir. Covington, Georgia, and Douglasville.
Okay. So they're close. You can visit them.
Yes.
But they don't live with you.
No, sir.
Does Ms. Hollis have kids?
Yes, sir.
How many?
2.
Do they live with you?
Yes.
So your household at Mathewson, or wherever it is, it's you, Ms. Hollis, and her
2 daughters.
Okay. How old are they?
One just turned 13 and 17.
17?
Yes, sir.
Okay. All right. So I assume they're both in school.
Yes, sir.
What is it, the work that you do?
I'm an estimator for a demolition company.
So that's reverse demolition. You look at something, reverse estimating. Instead of saying, it would cost this much to replace this house, you'd say it would cost this much to knock this down.
Yes, sir.
Okay. How much does it typically cost? I have a 2-story house. How much would it cost to knock it down?
Between 2 stories, so we say about 2,500 square feet. It'll be about, depends, between about 27,000.
Really? But
Yeah.
demolition includes hauling everything
Yes,
away, or just knocking it down?
That includes the waste, the hauling, the dumpsters.
So all that's
the
left is
machines.
dirt.
Yeah, to grade it to graded
Okay.
dirt level.
So it's the complete package.
Yes, sir.
And what would make it more, assuming I don't have asbestos or uranium?
Now, if you have asbestos, then you would have to get the property abated.
I don't assume I don't have any of that. Why would it be? You said it depends. Like, what's a big variable? Like if there are trees in the way, or a mean dog?
It just depends. If you have a basement, then we have to demo the basement also.
And fill
fill the basement and level it, and the waste. How many dumpsters it's going to take to get rid of it?
Okay.
If you want your foundation, the footers and slabs to be removed, it just all depends.
Okay. And you do the estimating. You don't then bring in the backhoe and knock it down.
Oh yeah. Once we estimate it, then me and my team, we go out and we do the job.
So you actually rip houses down?
Yes.
That'd be more fun than
I was
estimate.
working in the field for about 10 years, but then I'm currently working from home, so I just sit at a computer now.
Okay. When this is resolved, can you get back out in the field, or
That's what I'm trying to do.
Okay.
I've been at the house for too long.
Yeah, I bet that's what you.
And I've been incarcerated a little too long. So.
Well, that part ended. Okay. Any context you can give to me to this tray notion? that's a new weapon for me. Why would Ms. Hollis have said she got smacked with a tray?
It was actually, Your Honor, it's like a weed tray.
Oh, okay. So it's not like, hey, here's your meal, that kind of thing. It was for smoking.
Yes, sir.
Okay. All right. Mr. Jaluk, for us to process all this, I need to get everyone's signatures on the indictment. Do you authorize my staff to electronically sign the indictment indicating your 2 misdemeanor pleas?
Yes, sir, I do.
Ms. Wood?
Yes, Your Honor.
Ms. Willingham?
Yes, Your Honor.
Okay. I find there's a factual basis for the great weed tray fight that you had with Ms. Hollis. So I'll accept your plea to the 2 misdemeanors. I also find that your plea is knowing and voluntary. Knowing means you've understood everything we talked about, and voluntary means no one's forcing you to go forward with this, but to use your words, you're just ready to move on. Is that fair statement?
Yes, sir, it is.
Then I'll accept your pleas. Did you have conditions to probation? I know it's basically 24 months to serve 5, balance probated. And I was taking some notes, but I didn't have any conditions.
No violent contact with Ms. Hollis and complete family violence intervention.
The usual. Okay. I'm going to add one to that. So here's your sentence. Count 1, which has been reduced to family violence battery misdemeanor, is 12 months to serve 5 months with the balance on probation, and you'll get credit for all the time you've been in. So I trust you were in for more than 5 months and a day. All right. Count 2 will be 12 months. That'll run consecutive to count 1. So it's a total of 24 months to serve 5 with the balance on probation, which would be 19 months on probation. Special condition number 1, no violent contact with Ms. Hollis. You can continue to live with her, but you put your hands on her, you hit her with a gun or a tray or whatever. Not only is that a new crime, but that'll probably cause your probation to go up in smoke. You'll need to complete a family violence intervention program, which is a series of classes to help you and maybe Ms. Hollis work through disputes that are naturally going to occur as you grow older in a way other than getting physically violent. And I'm going to have you submit to a drug and alcohol abuse evaluation. And if that expert recommends any treatment, you'll need to follow that course of treatment. Ms. Willingham, anything else in Mr. Jaluk's case? Ms. Wood, anything else?
No.
You have any questions?
I just want to have one more question.
For your lawyer?
The bond. What do I have to do to get my money back for the bond?
Was it a 10% bond? I had it up on the screen.
It was.
A great question. I'm guessing, but Ms. Wood can help you with that. You're going to get what's called a final disposition, maybe even today. And I bet if you go down to the jail and say, look, it's me, final disposition, then about $2,500 ought to go back to you. It won't go to you directly. It'll go whoever put it up. Yeah. So if it was Ms. Hollis, you ought to thank her for putting that money up.
My boss, the owner.
Oh, well, you thank him. But that's how you'd get it back, is showing, look, my case is resolved. Okay. Don't go anywhere though. Ms. Nelson, is misdemeanor probation still rattling around, or is it too late?
I just called him on another case. I might be able to get him again, so he can wait.
Okay, so you need to wait here, back there on one of those benches, and misdemeanor probation is going to come meet with you just to get you signed up and give you reporting instructions. Okay?
Okay.
All right, good luck. Start knocking those. My house, by the way, I do not want demolished. I have not paid you or anyone else, so don't show up.
U.S. National Recycling.
All right, good to know. I'm a big fan of keeping houses up. So we've got one more plea. Ms. Jackson, are you able to stay, or do you want to give me in advance, or do we not have one more plea? Okay, we'll take 2 minutes to sort that out, and I'm happy to get the information in advance from you, Ms. Jackson, because I know you usually have a 4 o'clock, the whistle blows and you slide out the room.
Okay. Your Honor, could I ask one quick question about position 1?
Position 1?
Yeah.
Yeah, Mr. Trapatis? Yes, ma'am.
Did he get probation, or was it just further notice?
Mr. Trapatis, his case is wide open still. Nothing's happened with that one. He may be back here on Monday. He may be investing a lot of money in a lawyer who's going to, I don't know, get a different outcome from Ms. Wood, but we'll see. So there was further notice. Yes, ma'am.
Okay, just let me know when you're ready for that next position.
Okay, we'll do. And Ms. Taylor, I assume we've got you, there's only one more plea, but if it goes forward, that'll take us till about 4:30. We've got you till quitting time?
Yes, sir.
Great, thank you.
You're welcome, Your Honor.
Your Honor, I apologize for asking why Ms. Feely is gone, but did she formally say that the defense would be okay with the doctor testifying virtually?
That's the sense I got. I'm not gonna, she's not here, so I'm not gonna say I would force it, but she seemed anxious to move the case forward if it could move forward. And it didn't sound like the doctor's testimony was dispositive one way or the other. I mean, you need it, but I didn't get the sense that she had an issue with that. But it might be worth just an email, the three of us and Ms. Nelson, locking that in. And that might help you get more comfortable about whether you need the local doctor or not.
Yes, sir.
So I will get an email out, whether it's today or early tomorrow, to all of you. There may be no Shapiro cases left if this goes forward. Otherwise, to all of you as to the order that we'd call stuff out on Monday. And it may even be not Monday. If for whatever reason I decide we're doing Miss Seals, that is, I mean, we might pick the jury on Monday, but that's all we could do. And then we'd wait till later in the week.
Yes, sir.
Did any of that stuff go away? Yes, Jaluk just went away. So Ms. Willingham's number one, gone. 23. Robinson did not go away. Dixon may go away. Clark did not go away. Seals did not go away. And Lloyd didn't go away, but we may not be able to reach Lloyd. All right, those were your top ones. As between Ross and Hewley, those are two different lawyers. I was going to say, which one do you want? But it's not the same lawyer.
I think Mr. Jordan and I are going to confirm ourselves on Mr. Ross and make it some kind of decision.
Okay. You also should let me know if I send that list out and you talk and say, hey, we would really rather, having conferred, have this one ahead of that one. I'm happy to shift it around a little bit.
Yes, sir.
This is 3 years probation.
Yeah.
3 years probation.
Concurrent. So total 3 years. They had said 5, and as I heard more about it and whatnot, I said, I'm gonna give you 5.
Okay.
If it's any consolation, I've got lots of not
I'm sorry, pardon me?
if it's any consolation, I got lots of not nice words just to try and get some resolution this week.
Not nice words from whom?
Me, from lots of my victims. Yeah.
Oh, well,
They're not a fan of me this week.
but did you?
Last one, I had a lot of people who were-
But you are in the unit where you get it in both directions. You could have a victim say, I can't believe you're making this go forward. Why don't you dismiss it? Like, you know what? I have pictures of you with a broken nose and the weed tray sticking out of it. But then you also have some who, because it involves a former intimate partner, like, why are you not getting life sentence? Because you know what? There's like a fingerprint right here. That's it.
Yeah, no, it wasn't those not nice words this week. It was the other way around.
Okay. Well, it is.
It's part of the trade.
Exactly. I was going to say, it comes with your specific line of work.
It does. May I be excused?
Yes, ma'am. Thank you for your time. And I'll get that email out and then let's just exchange thoughts if that creates too much heartburn. Okay. Ms. Wood, what are we doing with Mr. Dixon?
He's not gonna be a plea today, Judge.
Okay, let's get some stuff though, voice to voice. Mr. Dixon, come on out, please. All right. Ms. Taylor, I'd like you to take this down if you would. It's not a plea, but I do want to make a record of my conversation with Mr. Dixon.
Will do, Your Honor.
Thank you. This is position 31, State versus DeMarcus Dixon, 22 SC 184604. Mr. Dixon is charged with aggravated battery, 2 counts of aggravated assault, 2 counts of terroristic threats and acts, felony cruelty to children, a gun or knife possession. Is it a knife that's alleged or a gun?
A gun, Your Honor.
2 gun charges as well. So a host of charges. Mr. Dixon's been in jail for a while on these charges, and we have the opportunity to take his case to trial on Monday or resolve it today. Mr. Shapiro, if Mr. Dixon were to enter a plea today, to what counts would it be? Would anything shift on that front? And then I think more important to Mr. Dixon, what would the state be recommending?
So Judge, the state had previously made an offer to resolve the case in which Mr. Dixon would be pleading to counts 1 and 3 only. The state would be moving for a dismissal of count 2 as well as counts 4 through 8. So in exchange for the guilty plea to the charges of aggravated battery and aggravated assault, the state was going to recommend 20 years to serve 8 in custody with the balance on probation. In addition, Mr. Dixon has 2 other unindicted cases that are currently pending. Those case numbers are 22 CP 213455 and 22 CP 209513. The state would dismiss Mr. Dixon's pending matters as part of the negotiated plea agreement.
Okay. Do you know the nature of the allegations in those 2 cases?
One moment, Judge.
Okay. Is it, I know you shared with me when you and Ms. Wood were both talking with me about the case that there are multiple alleged victims in Mr. Dixon's case in chief here. If he pled to counts 1 and 3, is that 1 victim or is that 2 victims?
That's 2 victims, Your Honor.
Okay, got it.
And as for the unindicted matters, 22 CP 213455 is 2 charges: criminal damage to property in the 2nd degree and conspiracy to commit a felony. 22 CP 209513 is 3 charges: 1 felony charge for theft by receiving stolen property, 1 misdemeanor criminal trespass and damage to property, and obstruction of a law enforcement officer. I also see, Judge, now that I have it pulled up, Mr. Dixon does have another case that's actually before this court that is 22 SC 185350. Those are 2 felony and 1 misdemeanor charges related to drug possession. I can confer with Mr. Gordon, but I'm sure he'd have no objection to me resolving that case as part of the negotiated plea as well.
So the 20 to serve 8 credit for time served, we're getting close to a year, would resolve the 2 unindicted cases would be dismissed, whatever the term is for unindicted cases. And then unless there's something incredibly bizarre in the 22 SC case, that would be run concurrently with 8 years.
That would resolve all of Mr. Dixon's outstanding matters in Fulton County.
Got it. Is there a recidivist notice in place, or would there be one filed should Mr. Dixon go to trial?
Mr. Dixon has 16 prior cycles. However, he has no prior felony convictions.
Okay. The offer of 20 to serve 8 with the dismissal of the majority of the counts, including, I guess they're all felonies, all the counts. Does that expire if Mr. Dixon hops on the bus to go back to Rice Street today, not having accepted it?
Yes, Judge, that would expire today.
Okay. All right, Mr. Dixon, I actually want to talk with you, but I need to know what the parameters were of the situation so that you and I could have an exchange. I'm understanding the state's offer to be 20 years to serve 8, and it wipes the slate clean. You've got 4 things rattling around right now: 2 indicted cases, 2 unindicted cases. It sounds like the most serious is the one that we're going to go to trial on next week. That's the aggravated battery, aggravated assault, and cruelty to children. Do you understand what the state would be recommending to me if you decided to enter a plea today?
You say what?
I want to know if you understand what the state's recommendation is. If you decided, hey, what, I want to do this thing, and I say want, I understand you're not excited about any of your options. I wouldn't want to go to trial with these charges. I don't know that I want to serve 8 years, but it's choice time. And so if you were to say, all right, I want to resolve all 4 of my cases, the state would say, all right, then we're going to recommend, Judge, that you sentence Mr. Dixon to 8 years in prison, followed by 12 years of probation with credit for time served. That's what the state would be recommending. Do you understand that? Yes?
So y'all understand?
Yeah.
Yeah, I understand.
Okay. After today, if you go to trial or you decide, oh man, here's a jury, I don't want this jury here in my case, I plead guilty, the state could recommend something different and higher. You wouldn't get to say, hey, I want that 8 years back. It may be that Mr. Shapiro says, Now our recommendation is 10 years or 20 years, but it could be a number higher than 8. Do you understand that? Yes?
Yes.
Okay. Do you have any questions about what the state is recommending?
Is there any way I can serve less?
So that's a great question. The way you would serve less would be if I sentence you to less. I'm the one who decides what your sentence is, not Mr. Shapiro. He will make a recommendation, and he is very transparent. He's going to recommend 8 years to serve, followed by some probation, and that resolves your 4 cases. He is not offering less than 8, but he doesn't control what I do. He influences it. He'll tell me why he thinks 8 is a reasonable number. Ms. Wood, who has gone to bat for you a number of times, and I suspect has gotten the number down to 8, has gotten it as far down as it's going to go. Mr. Shapiro has said, that's it. With 4 cases and what happened in this case in particular, not comfortable going less than 8. The value for the state is that the victims don't need to come in here, and there's at least one child victim who would need to come in here, and that's traumatic. And the not having to make the kid go through that, the state's willing to offer you 8. I don't know what I'd do because I don't know you. I haven't heard about this case. I might hear all this information and say, I think that 7 is the right number. I might hear all this information and say, I think 12 is the right number. But at least today, you've got Mr. Shapiro advocating for 8. If you go to trial and you're found guilty, I suspect, I don't know, because again, Shapiro is going to do what he does. He's going to say something higher than 8. I do know that I will have heard from all the alleged victims in the case. And if a jury finds you guilty, they're not alleged victims anymore. The jury is saying the guy who did these things, DeMarcus Dixon. And then I need to figure out, well, what do we do with someone who did these things? And your exposure is well over 40 years. I'm not saying I give you 40 years, but if we do all this math, it's a number that I don't know what would merge. So I don't want to give you a specific number, but I can tell you that it would be far north of 40 years if the state said, we think you should sentence Mr. Dixon to the maximum. And I went along with that. It's multiples of 8. 8 is the offer now. Of course, if you're found not guilty at trial, you hit the jackpot because your sentence is 0. Your sentence is, well, let's deal with these other cases. These other cases are pretty small, and I think we'd resolve those, and you go home. So you've got some interesting options. If you go to trial, you're rolling some big dice. You've got a great lawyer, but she's not a magician. And if the evidence is not good evidence for you, if people are going to come in here and they're not get, hey, the guy had a mask on, I don't know who did it, but it's in fact, it was my boyfriend, or it's my dad, or my uncle, or my cousin. And you're going to be thinking about how a jury processes that. I don't know the facts, and I don't want you to tell me the fact, hey, I got a great alibi, or they deserved it. That's a conversation for you and Ms. Wood. And then come next week, conversation with the jury. So I just want to be comfortable when you're saying no thank you to Mr. Shapiro, that you've really thought it through. You strike me as a thoughtful person. I know Ms. Wood has talked to you a lot about it, so I'm not worried about, oh, you know, my lawyer didn't talk to me. Now, she may have only recently brought you a new offer. That's not Ms. Wood's fault. She shares it with you as she gets it. And so the state's offer may have changed, but here we are at this crossroads. I need you to tell me, now we're person to person, not through Ms. Wood, whether you want to go forward with trial, because it's likely we would try your case on Monday, or if you want to go forward with the plea. And I'm neutral. I'm not leaning in either direction. I'm here to handle the plea, or guess what? I got to be here on Monday anyway. And so we'll get a jury in here and figure out what they want to do. Do you want to talk with Ms. Wood for a minute, or you know what you want to do? Okay, Ms. Wood, with your permission, I'm going to get criminal history information from Ms. Jackson so she can go. It sounds like it's going to be no convictions, but we'll just get the cycles, and I'll get that on the record when you come back if we're going forward. Okay, thank you. So we'll go off the record. If you could please share with me, Ms. Jackson, the criminal history information you have for Mr. Dixon.
The defendant has 18 cycles. The defendant's last arrest was June the 1st, 2022, with the City of Atlanta Police Department for theft by receiving stolen property and misdemeanor obstruction of an officer and criminal trespassing. There was no disposition for that arrest. Also, the defendant appeared to have an outstanding hold out of East Point, Georgia, for a failure to appear. The date on that warrant was December the 13th, 2022. The defendant does have misdemeanor sentences and convictions. First one in 2017, the defendant received a nolo contendere sentence out of Clayton County for obstruction of an officer. There was one in 2015 out of Baldwin County, Georgia, for disorderly conduct. There was one in 2014 out of Baldwin County, Georgia, for obstruction of an officer. And there was one in 2012 out of Clayton County for disorderly conduct. I did see several probation violations. There was one in 2017, one in 2015, one in 2014. Nothing in addition, Your Honor.
All right. Thank you so much, Ms. Jackson. Do you need any information from us or are you good to go?
I'm good to go. Thank you.
All right. We'll see you soon.
Thanks. Bye-bye.
Bye. Okay. We are going to be on a pause. I'm going to stay right here. We're going to let Ms. Wood speak with Mr. Dixon. Mr. Jaluk, you're still here because you're waiting for misdemeanor probation?
Yes, sir.
Or you just enjoy 8D?
I'm just waiting for misdemeanor.
Okay. Is he using the restroom or? No, I'm sorry, he needs to come back out just so we can close the loop with whatever closure means today. Ms. Nelson, are we going to be able to connect Mr. Jaluk with misdemeanor probation today, or should we let him go?
I'll give him a call just now and see. I have to submit that to you.
Can you say that again?
I'm going to call him right now to make sure they'll be here.
Okay, thank you. All right, let's go back on the record, please, with Mr. Dixon's case. We took a break so that he could confer with Ms. Wood. Ms. Wood, what's the plan for going forward?
Mr. Dixon still wants to go to trial.
Okay. Mr. Dixon, as I said at the outset, that's your right. And the jury's not going to hear about the fact, maybe you were going to plead or anything like that. What they will hear is that you are presumed innocent. And it is the state's burden to prove, if it is able, your guilt beyond a reasonable doubt as to one or more of the charges. It is likely that yours will be the case we try next week, but there are a few others that are in the mix. I need to talk with these lawyers about availability and readiness, et cetera. Ms. Wood has always said she's ready because she knows that you've been in jail and want closure and are entitled to closure on this. So don't be surprised if you're brought over on Monday. Ms. Wood's going to need to have clothes for you. So I don't know if you've got family that she can connect with, but you're not going to want to appear in front of the jury in the blue jumpsuit, but we'll want you wearing street clothes because your status of being an inmate isn't relevant to this case. And so we try as best we can to disguise that fact unless it's somehow relevant to what's being presented. Okay. Do you have any questions, Mr. Dixon?
No.
Okay, thank you. I think we're done. Mr. Shapiro, anything else you want to get on the record in connection with Mr. Dixon's case?
So Judge, I will make an oral motion just for a continuance to the next available trial calendar. I know when we were in here previously, we discussed that we had some issues with contact with our juvenile victim. Those issues have now been resolved. However, we were only contacted by an attorney who's representing her in an unrelated matter within the last couple of days. Miss Letitia Jones, who is the juvenile's mother, is present on Zoom. She was notified about court today. So we do now have the issues resolved. However, we would like additional time to meet with and to prepare the juvenile victim for testifying in this trial.
Got it. Okay, I appreciate that. Ms. Wood, your view on continuing the case, it might give you an opportunity to speak with this person too, if you were even given permission, but you may be ready to roll.
I understand the state's position and I don't have an issue with it. I know Mr. Dixon though was very eager to have his day in court.
Okay, so on his behalf, you're opposing the motion to continue?
Correct.
Okay, that's on the record. I will consider that as well. And you brought it up before. I didn't forget it. And I'm not trying to disadvantage anyone here, just trying to figure out the best way to use next week's jury time. Are you expected in other courts for trial next week, or this is, if we go on Monday, we get you for that sort of clears the deck for you?
Not for trial, Judge. I do have a sentencing in a case that was tried last week, Monday morning in front of Judge Adams. However, I suspect I could be done with that by 9:30.
Okay. Well, we'll see what happens. All right. If there is nothing else, we can go off the record. Thank you, Ms. Tucson, for being here. Thank you, Ms. Taylor. Is your understanding, Ms. Taylor? Uh-oh, trouble. Are you here the rest of the week or literally it was just today?
I was just here for today.
All right. Well, I appreciate everything you did. How did we find you? Did Mr. Dawson reach out? Are you part of our pool or?
No, I am not. I'm with American Court Reporting.
Are you?
So someone definitely had to have called in.
Okay. Are you in Georgia or are you like in Idaho right now?
No, I'm in Georgia.
Okay. All right. Well, good. Well, thank you for helping out. We'll figure out who is helping us tomorrow.
And it was Mr. Dawson that called.
Good. I'll let him know he did a good job.
Thank you so much, Your Honor.
Okay. Bye-bye.
Bye.
I think they may be here. All right. I'm signing the sentence right now. It just got to me though. You know how it works. All right, I just sent his sentence back to Ms. Nelson, so they stick around for it, or let her know it's en route. I'll wait till Ms. Wood comes back out. I just want you to flesh out a little bit more the Dixon situation. Just meaning the prep you're trying to do. So I have to look through this. We had fewer pleas than we thought. Some were close. It doesn't sound like Dixon is going to shift much in terms of offers, nor should it. Are any of your cases likely come Monday to have a different offer perspective, or you've pushed as much as you've wanted to push, as hard as you can push with your supervisors?
There's a chance on Tony Clark, because I do have one review left with Deputy Davenport, that the offer may change
Okay.
On that case, but other than that, everything is, those are the best offers that I can possibly give.
Okay. Well, Clark and Dixon would be my default top ones because they're in jail. I mean, someone like Ms. Seals, we got to get closure on her case. She's clearly never going to plead, but she's out and victim's doing her own thing. Lloyd, I would also prioritize. He's been in forever, but we can't clone Mr. Melnick, which may be a good thing for society, but we can't. So that's probably where I'm leaning. Ms. Wood, I was waiting for you to come back out. I wanted to give Mr. Shapiro, we're not on the record anymore. In fact,